Mr. Chair, you're muted.
Thank you. Our next participant, Conservation Colorado, who is represented by Matt Sura. Evidently, Mr. Sura's internet has gone down, and he's trying to find an alternate way to join us. We also have reached out to the industry group to see if perhaps they could go next. But long and the short of it is we need about 5 more minutes before we're able to sort of know what's next. So if you just want to mute and hang out, when I show back up, we'll be ready to go. Following that, once they get their internet up and running again. So I believe that Ms. Larson is bringing to the panel the folks that are part of the industry group for a 1 hour and 5-minute presentation.
Thank you. Good afternoon. I will be introducing the industry group today. I just want to make sure we have everybody on from our group. If you just bear with me for 1 second. Okay. Good afternoon, commissioners. My name is Kelsey Waselinki. I'm a shareholder at Jost Energy Law. Thank you for the opportunity to present the industry group testimony this afternoon. Our group is composed of a number of industry operators, as well as the oil and gas trade groups, including API, COGA, West Slope COGA, and the Energy Council. We greatly support the revised Draft 900 series rules, and especially commend the staff for their hard work and effort in drafting the proposed rules. We do, however, believe that some changes and clarifications are necessary for the proposed rules to adhere to the necessary and reasonable standards in the Oil and Gas Conservation Act, and to avoid certain unintended consequences. To point out where we believe changes in the draft rules and statement of basis and purpose should be made, we will have 5 witnesses presenting this afternoon and 3 additional witnesses available for questions. We do not anticipate utilizing our entire 65 minutes of time this afternoon and would like to reserve our remaining time for our rebuttal and closing statement. First, Chris Colglazer of Beatty and Wozniak for COGA will address the definitions of venting and flaring, cumulative impacts, and pit emission regulations in Draft Rules 903 and 904. Second, Catherine Gillen, who's the Environmental Manager for Great Western, will address the requirements for a gas capture plan in Rule 903E1 and proposed edits to the draft statement of basis and purpose for that rule. Third, Dr. Jessica Ryman Rasmussen for API will discuss her comments to Table 915.1 and specifically why changes to the regulation of total petroleum hydrocarbons in soil are needed. Fourth, Brett Middleton, who's the environmental lead for the EHS team of Caris Operating, testifying for Caris, West Slope COGA, and COGA, will present on several cleanup concentrations in Table 915.1. And last, David Stewart, who's the Vice President of EHS and Regulatory for Crestone Peak, will address comments to proposed Rule 915 and Table 915.1 with respect to the determination of a pathway to groundwater and the 48-hour well liquid unloading notice in proposed Rule 903 D1E. As you consider the testimony of our industry witnesses today, I encourage you to ask any questions of our 2 CDPHE air regulation experts. In addition to Chris Colglazer, who will present to you next, Jennifer Beaver, who submitted written testimony for Great Western, is on our panel today and available to address the AQCC's regulation of pollution and the interrelationship with the proposed 900 series rules. In addition, Marcia Sonderfan, a senior EHS specialist for High Point, testifying on behalf of API, is available with respect to her testimony on venting and flaring. And finally, Christy Woodward, the Senior Director of Regulatory Affairs for COGA, is available to answer any questions you may have about the incorporation of T-norm, the treatment of recycled produced waters in the draft rules, and the consequences of making proposed Rule 903 D6 regarding uncontrolled VOC emissions retroactive. And with that, I will turn it over to Mr. Colglazer.
Thank you, Kelsey, and good afternoon, commissioners and staff. I'm Chris Colglazer. I am an air quality lawyer and former deputy director of the Colorado Air Pollution Control Division. Next slide, please. I'm speaking for the industry group about venting and flaring, cumulative impacts, and PITs. Staff has worked closely with industry, the air division, and environmental groups to improve these rules, and together we've made real progress and narrowed the remaining issues. Next slide. Any evaluation of venting and flaring should begin by recognizing that these are extremely rare in Colorado. Less than 1/4% of produced gas is flared. We've heard concerns about routine flaring, but flaring is already not routine here. Industry and staff are largely on the same page regarding venting and flaring, and we support most of the staff's proposal. But we do seek targeted improvements to clarify the activities and emissions that are subject to the Rule 903 limits. First, the statement of basis and purpose should define the natural gas subject to these rules using the same language for both flaring and venting. This is just a conforming change. Second, the Commission should direct staff to develop guidance so all parties know what constitutes venting or flaring. Guidance is necessary because these terms are fiendishly difficult to describe, and any definition in a rule is bound to leave some unanswered questions. We also endorse Great Western's position on gas capture plans and the Small Operator Society position on well liquids unloading. With these changes, the rules will be clearly defined to cover only the emissions of concern to the COGCC. The rules will also delineate the roles of this commission and the Air Commission without ceding any of your authority. As Director Murphy and staff testified yesterday, the goal is to prevent the escape or combustion of natural gas that should be gathered and sold. This concept is easy to grasp, but hard to codify, and certain gaps remain in staff's proposal, which again we generally support, that need to be filled in. Next slide. The draft rule and SBP define flaring and venting as the combustion or escape of natural gas, and that term is in quotes. The SBP explains these terms by saying, the Commission's intent in regulating venting is to address the natural gas coming out of the well that should be or would be sent to a gathering line or otherwise put to beneficial use. This statement only mentions venting, and the SBP should clearly apply the same concept to flaring by inserting the words flaring and venting into this sentence. So that's our first requested change, as shown on the screen in blue. The SBP also explains that the requirements for flaring and venting do not apply to hydrocarbons that normally evaporate or vaporize from liquid hydrocarbons, including flash gas. This statement applies to both flaring and venting, which is helpful, but nonetheless, it can be hard to tell whether methane enters the gaseous phase through separation, evaporation, or flashing. And so that makes the definition a bit unclear. And let's look at some examples. On the next slide, starting at the wellhead on the far left, everything that is produced flows to a high pressure inlet separator, labeled here as number 1. And it's divided into 3 streams: natural gas, which goes to the sales line on the bottom of the screen, along with oil or condensate and water in separate streams. The oil and water streams each contain some methane, because no matter how perfectly you separate the gaseous methane from the oil, there will still be additional methane dissolved in the liquids. Now, this methane from the inlet separator is clearly natural gas that is subject to the venting and flaring rules. But if this natural gas passes through an on-site compressor, labeled number 4, or glycol dehydrator, labeled number 5, on its way to the sales line, there will always be emissions from these devices, and it's unclear whether the venting and flaring rules apply. So the Air Commission rules require operators to control emissions from the compressor and dehydrator, and the guidance should clarify that this required combustion is not flaring. So that's the natural gas stream that comes off of the separator. Again, that's labeled as number 1. There's also an oil stream coming off of the separator, shown in the black arrow. The oil stream, leaving the high pressure inlet separator, contains methane. On its way to the storage tank, the oil might pass through a flash gas separator, labeled number 2, often called a heater treater, and it might pass through a vapor recovery tower, number 3, or it could pass through both. And then the oil goes to a tank. These devices at number 2 and 3 are separators. They help to recover natural gas for sale and reduce emissions by removing methane from the oil. Mr. Duranlo testified yesterday that the methane from these low pressure separators is natural gas, meaning the venting and flaring rules apply. And this can be true if there is enough gas to be routed to sales, but that is not always the case. When the heater treater or the vapor recovery tower don't produce enough gas to consistently gather for sale, the venting and flaring rules should not apply to these pieces of equipment. And there are also more complicated configurations that deserve discussion in a guidance document. But sometimes the methane from these low pressure separators, again, number 2 and 3 on the screen, should be captured and sold, and there are times and places when it should not be. and so we request guidance to clarify the difference. The rules for the heater treater and the vapor recovery tower are important. These devices are beneficial. Having multiple stages of separation allows the tanks to operate without venting, and hundreds or thousands of facilities in Colorado were approved or permitted to operate this way after submitting an engineering design analysis to the Air Division. Many of these devices were installed under a court-approved consent decree. Staff's proposal would place many of these facilities immediately out of compliance, forcing them to shut in and stranding millions of investment dollars. To avoid this unjust result, on the next slide, we propose revising the statement of basis and purpose to develop guidance, direct staff to develop guidance, clarifying the emissions that are subject to the venting and flaring rules. We also propose revising the SBP to state that operators holding existing permits for heater treaters and vapor recovery towers may continue to operate until this guidance is issued, and that combusting high pressure gas is not illegal flaring. On the next slide, turning now to cumulative impacts, we support staff's October 20 proposal, and the Commission should reject the proposals from some parties to limit or curtail permits as a GHG reduction strategy. Numerous measures, including design improvements, tankless production, and infrared camera inspections, have achieved large emission reductions from the oil and gas industry. The Regional Air Quality Council's ozone inventory shows that hydrocarbon emissions from oil and gas operations in the non-attainment area fell more than 40% between 2011 and 2017, with another quarter reduction estimated since that time. While some data indicated flat methane emissions, the Air Division Director, Gary Kaufman, stated on October 23rd that recent preliminary data from aerial monitoring suggests methane reductions have been larger than previously thought. The Air Commission will consider additional pneumatic controller regulations in December and hold a large rulemaking next December. So large amounts of emissions data are also being collected or soon will be. This commission could use this data to consult with CDPHE, and the Commission may satisfy the Act's requirement to address cumulative impacts by receiving and considering annual reports and recommendations and taking any action deemed appropriate. Next slide, please. The Air Commission recently adopted sector-specific greenhouse gas reduction targets for the oil and gas sector, as you've heard. These targets, as shown on the screen, are more stringent than the House Bill 1261 targets, and the Air Commission is quickly adopting rules to achieve them. Some parties, including Western Resource Advocates and others, have asked you to limit the issuance of permits as a greenhouse gas reduction strategy. There is no basis for this, and doing so would be unnecessary and unreasonable in violation of the Act. These proposals to limit permits as a GHG strategy are unnecessary because better options exist. We don't yet know what rules the Air Commission will promulgate this December or next December, but the division and others have suggested various possibilities, including rules for deeper methane leak reductions, emissions monitoring, intermittent maintenance activities, pneumatic controllers, and others to be determined in the stakeholder and rulemaking process. Last Friday, the division staff indicated that the oil and gas sector-specific targets can be achieved without limiting production. Finally, despite the claims in Western Resource Advocates' written filings, neither the Energy Office nor any other agency have asked this commission to consider curtailing permits as a greenhouse gas reduction strategy. Next slide, please. My last topic involves Rule 903(d)(6) and the standards for pits. We ask you to reject this unreasonable proposal because it is a major barrier to recycling or reusing produced water. Fracking uses large volumes of water, and operators cannot recycle or reuse it without somewhere to hold it. The proposed rule would threaten existing recycling ponds and block most, if not all, new ones. And to be clear, these so-called pits are not just holes in the ground. They are designed and engineered to protect the environment and minimize adverse impacts. They cost millions of dollars. They recover hydrocarbons from the water, both to salvage valuable products and to reduce emissions. These facilities save more than 65,000 barrels of water per well. They reduce the need for injection wells, and they avoid 40 or 50 round-trip truck trips per well per day. So protecting these beneficial assets is critical to conserving fresh water. Next slide, please. The proposed rule is unworkable. Operators have few options to reduce emissions below 2 tons per year. For example, operators can't collect or route vapors from the pond to a flare. The The rule is also unreasonable because it relies on uncontrolled actual emissions, meaning the operator must ignore the real emission benefits they achieve by recovering hydrocarbons from the water. And a statewide ban on new pits above 5 tons per year may effectively ban all new water recycling ponds. No other emission sources are subject to this type of hard emissions cap. Tanks and other equipment with emissions above certain thresholds have to use emission control devices, but the tanks are still allowed. Most importantly, the rule puts existing facilities at risk. If a house moves in next door, the recycling pond would likely be forced to close. And would you invest millions in a new pond that could be forced to close if a neighbor moved in? Operators would have to control the surface rights for 2,000 feet in every direction to ensure that no one encroached upon them. This is inconsistent with Rule 604, which applies the setback requirements to well production facilities at the time of the Form 2A and not over the life of the facility. The statement of basis and purpose also lacks factual support for the asserted health risks from these ponds. The SBP and witnesses have pointed to the 2 ton per year tank emissions control threshold, but tanks are allowed to emit more than 2 tons per year, and the setback from well production facilities was adopted in response to facility-wide emissions, which may be up to 50 or 100 tons per year for a minor source under Air Commission rules. So the proposal is unreasonable and not justified or appropriate. Finally, before I turn this over to the next witness, I do want to respond just quickly to comments that were made by Mr. McCabe about the desire to control emissions from tanks or control flaring from tanks. And I just want to point out that the Air Commission scrutinizes these tank emissions in great detail. It's appropriate to rely on their expertise as staff has proposed. CDPHE has previously considered tank VRUs. They're familiar with this technology and the safety risks, and they are in position to reduce these emissions. So I'm happy to answer any questions about that proposal. And now I will turn it over to Katie Gillen from Great Western Operating Company.
Thanks, Chris. Good afternoon, commissioners. My name is Catherine Gillen. I am the environmental manager for Great Western Operating Company. We are the largest family-owned private company in Colorado, operating exclusively in Weld and Adams counties. Next slide, please. A summary of my testimony. We support the staff's revised requirements in Rule 903E1 that an operator may certify connecting to a gathering system by the commencement of production or submit a gas capture plan. This change acknowledges that a midstream contract may not be finalized at the time of Form 2A submittal and may contain confidential business information. The rule remains protective and commits operators to having a gathering contract in place prior to commencing production. Second, we recommend that COGCC continue to work with the Air Pollution Control Division in the implementation of sections 903E1, 6 through 8 regarding BMPs to minimize venting, procedures to reduce well unloading, and anticipated volumes and separator sizing over the life of the well. For these 3 requirements, we recommend the Commission adopt some statement of basis and purpose language to ensure coordination with the Air Pollution Control Division for the reasons I will describe. Next slide. With respect to Section 6, COGCC proposes that operators provide a description of BMPs that will be used to minimize venting during active and planned maintenance at the time of the Form 2A submittal. However, much of this information may not be known at the time of the Form 2A submittal, particularly given the range of equipment and activities this could cover. And this same information will be required by APCD during the permitting process. Specifically, the proposed General Permit 11 will require the owner and operator to develop and maintain a description of best management practices implemented to minimize hydrocarbon emissions during routine and predictable events covered by this permit. COGCC has indicated its intent not to duplicate division requirements, yet its proposal would do precisely that. Implementation of this provision should be coordinated with the division. With respect to Section 7, this would require operators to describe the procedures the operator will employ to reduce the frequency of well unloading events. First, while the statement of basis and purpose appears to properly address the distinction between manual and other well unloading events, The rule makes no such distinction. Thus, the rule is not clear that it is about reducing the frequency of manual well unloading, although the statement of basis and purpose indicates that is the intent. This is another area where the requirement of BMPs pursuant to regulation number 7 will potentially overlap with existing regulations. Again, because of this overlap, coordination during the implementation phase will be critical. With respect to section 8, under the provisions of the gas capture plan in 903E1B8, and according to the statement of basis and purpose as part of the cumulative impacts information under 30419 for all facilities, COGCC is requiring that an operator provide anticipated volumes of the liquids and gas production and a description of how separation equipment will be sized to optimize gas capture. The statement of basis and purpose states that it intends for this information in Rule 903(1)(b)(8) to apply throughout the life of the well, indicating that the Commission intends for the information supplied to address how equipment will change over time as production decreases, to ensure that separation equipment is never below the production capacity. Great Western believes that in requesting and reviewing this information, COGCC must consider existing regulations, permitting, and guidance at the Air Pollution Control Division, including the extensive work the APCD has undertaken on emissions from storage tanks and their vapor control systems. Importantly, information regarding anticipated changes to separation equipment cannot be known by the operator, much less mandated or locked in place at the time of the Form 2A submittal. Operators must be able to identify, evaluate, and implement appropriate equipment changes in light of the specific production and design for a particular facility. Because separation equipment has an impact on emissions of other equipment, for example, storage tanks, operators amending their separation equipment will typically need to address those changes through permitting at the APCD. Great Western recognizes that this information will require increased dialogue during implementation and requests language that will require engagement with the APCD during such implementation. Specifically, Great Western requests the language to be added to the statement of basis and purpose as described. Next slide. To effectuate the coordination as discussed above, we propose the statement of basis and purpose acknowledge that collection of information will take into account existing requirements and that use and interpretation of such information will be coordinated with the Air Pollution Control Division to avoid unintended consequences. We further provide more specific proposed statement of basis and purpose language for addressing separation equipment, which, if not properly coordinated, could have the greatest unintended consequences. Thank you for your time and consideration in adopting these changes to the statement of basis and purpose that will help ensure operators can successfully comply with overlapping and potentially contradicting requirements between COGCC and APCD. I would welcome your questions and also have Jennifer Beaver, our outside counsel from Williams & Weiss, who has extensive expertise in AQCC's requirements for oil and gas. Thank you for your time. I will now turn it over to Jessica Ryman.
Thank you. My name is Jessica Ryman Rasmussen. I'm a senior policy advisor with the American Petroleum Institute, API. I have a background in toxicology and human health risk assessment, and a little bit more about my scientific background was provided on my bio and CV with API's responsive statement. Next slide, please. So my presentation today is regarding proposed changes for Table 915-1, particularly as regards total petroleum hydrocarbons, which I will refer to throughout the rest of the presentation as TPH. So I am going to discuss in particular the proposed 500 milligram per kilogram screening level in soil, the proposal to extend the carbon range from C28 to C36, and the proposed hazard quotient of 0.1. For each of these 3 items, I will explain problems that I've identified and the consequences of those problems, as well as options for improvement. And I will finish my presentation with the bottom line of what all of this means for the protection of human health. Next slide, please. So the largest problem with the 500 milligram per kilogram screening level for TPH in soil is that it has no scientific basis. And looking through the materials, you know, on the website to support this action, I could find no identified toxicity or exposure information or analysis thereof. I couldn't find any evidence that this proposed value has undergone any type of peer review by experts in the field. And consequently, I cannot find any evidence that substantiates any, that would substantiate any claim that this value would protect human health. And in fact, in my written expert witness testimony, I provide some examples for when it is not protective and for when it is overprotective. So I provide several examples when comparing this 500 milligram per kilogram value to EPA values, in which sites that are heavily contaminated with or skewed towards some types of TPH would there would not be protection of human health for a 500 milligram per kilogram screening value. I also provide another example where if sites were heavily skewed toward contamination with a different TPH, the 500 milligram per kilogram value would be overprotective or unreasonable. Next slide, please. So in addition to identifying these problems, I've identified some options to try to, that might help remedy the situation. So one option would be to simply identify and use existing soil screening levels for TPH that do have a scientific basis, okay? And EPA values do have that. I will be talking about those in a little bit more detail on my next slide. There may also be some other values out there that do have a sufficient scientific basis, but if there are, I personally am not aware of them. So if you know, the COGCC were to decide, you know, not to go that route and grab something off the shelf, if you were instead desiring to derive your own health protective screening values from toxicity and exposure information, that's another option. However, doing so in a scientifically supportable manner is really quite a lot of work. And just as a further caveat, I'll let you know that the large differences in TPH toxicity indicate that it's going to be very difficult to identify a single screening level that will be both human health protective and also reasonable. So it's going to be very difficult to identify a one-size-fits-all solution that isn't overdoing it in some cases and underdoing it in others. Next slide, please. So I'd like to talk a little bit more about US EPA's regional residential screening levels for TPH. So like the soil screening values proposed by COGCC, the point of the RSLs is to set screening levels so that they are protective for residential use. And when we're talking about residential use, what we're really worried about is protection of children that might come into contact with soil that's been contaminated by TPH. So unlike COGCC's proposed value, EPA's RSLs recognize the very large differences in TPH toxicity and chemistry. And they do this by dividing TPH into 6 different fractions and having RSLs for each. EPA's RSLs also have a scientific basis that support health protectiveness. And I'll go into this a little bit more in the following bullet points, what I mean by a scientific basis. What I mean is that on the toxicity side, the toxicity databases for each of the 6 TPH have been reviewed, and toxicity values that are protective of human health have been derived, and these toxicity values have also undergone peer review. EPA has also considered exposure information, and they have combined the considerations of toxicity and exposure information to derive a risk-based numerical value for each TPH fraction that is health protective. So there is a lot of science behind these numbers that can then be used to defend any claim that they're human health protective. Next slide, please. There we go. The next item that I would like to mention is the proposal to extend the carbon range from C28 to C36. Again, I could find no apparent scientific basis for this proposal, and so any claims of that rolling this into the 500 milligram per kilogram per soil screening value would be health protective wouldn't be able to be substantiated. Next, I'll note that the toxicity data that supports US EPA's RSLs indicate that the higher range TPH tend to be less toxic than those in the lower range. For example, for the high range aliphatic TPH, EPA actually bases its RSLs on mineral oil, which has pharmaceutical uses. The aromatic chemical in that high range is fluoranthene, which is a bit more, which of course is more toxicologically potent than mineral oil. But I wanted to give you an example of sort of what the toxicity is of compounds in that high range. Next slide, please. So two potential options for remedying this situation would be to identify and use TPH ranges that have a scientific basis, such as those provided by EPA. The other option would be to derive health protective screening levels from toxicity data and exposure information for hydrocarbons in this range. In my expert witness testimony, I did provide potential sources of data that could be used. It's toxicity information. But again, that's just the first step. A lot of additional work would have to be done in order to come up with a screening level for hydrocarbons in that range that's health protective without being unreasonable. Next slide, please. So lastly, there are some issues with fixing the hazard quotient at 0.1. The largest issue is that's not a site-specific approach. And we know that these sites can vary a lot in terms of the types of contamination that they have with TPH and other chemicals. Additionally, once one uses hazard quotients that are this low, it can be possible to get into a situation in which non-cancer effects can be more sensitive than cancer-related effects for chemicals that have cancer hazards that might be also on the site. Next slide, please. So options for addressing this problem. One option would be to follow EPA's RSL guidance, which uses a default hazard quotient of 1. It recognizes that sites can vary with regard to chemical composition, and so it allows for hazard quotients to be adjusted to the site. It also provides a caveat that reminds people to be mindful of whether or not cancer or non-cancer effects might be driving the screening level. And then furthermore, it encourages the input of regional risk assessors to ensure that actions are tailored to that particular site. Next slide, please. So I'd like to just wrap up by giving you the bottom line based on the information that I've presented to you today. Because there's no apparent scientific basis for these proposed TPH-related changes, unfortunately, COGCC is not going to be able to substantiate any claim that these proposed changes are protective of human health. And that concludes my testimony. Thank you.
Greetings, Commissioners, Director Murphy, and COGCC staff. My name is Brett Middleton, and I'm the Environmental Health and Safety Lead for CARES, where I carry out multiple functions centering on site remediation. I'm testifying on behalf of CARES, COGA, and West Slope COGA, specifically regarding the draft table 910 or 915-1. Next slide, please. To begin, CARES requests that the Commission make modifications to standards for certain components that I will address in draft table 915-1. Because current draft table 915-1 standard will require all Piance operators to seek relief for all oil and gas locations. Therefore, to reduce administrative burden on COGCC staff and to increase efficiencies, CARES requests that the Commission consider setting standards I will propose in the following slides. At this time, the path for obtaining relief to the concentration standards in draft table 915-1 is unclear, which makes it difficult for operators to determine immediate next steps. CARES seeks immediate clarity on who will make determinations for relief or alternative standards and requests that the process be efficient, obtainable, and determined in a timely manner. Furthermore, CARES requests the Commission provide clear guidance on how operators should handle compliance for current remediation projects under draft table 915-1. While Rule 915F allows for operators to seek the Director's approval to utilize table 910-1 for current remediation projects if the site is closed by January 15, 2020, there is no immediate clarity for how operators should acquire Director approval to continue remediation projects under the standard of table 910. How will this be achieved efficiently and in a timely manner in order to close sites? Next slide, please. CARES appreciates several modifications the Commission made to draft 900 series release in October 14, 2020, particularly the revised footnotes that allow regulatory flexibility for site-specific concentration standards. CARES was especially pleased to see that the standard for barium set at 15,000 milligrams per kilogram for residential soil level concentrations. This change means that operators in the Piance Basin will not be required to haul drill cuttings to landfills for disposal, which could have significant impacts on the environment. Additionally, CARES was pleased to see the incorporation of the practical quantitation limit, which we believe will allow for efficient lab analysis, which will lead to a focused determination in carrying out remediation. Next slide, please. This slide depicts a comparison of CARES's background soil level samples to draft table 915-1 standards for certain components. The blue text indicates components that I will specifically address. As proposed, several standards in the draft table 915-1 are below the naturally occurring background concentrations for soil in the Piance Basin. Next slide, please. For chromium-6, the Commission's proposed concentration limit for draft residential soil screening levels is 0.3, and the protection of groundwater soil screening level for this metal is 0.00067 milligrams per kilogram. The lowest PQL, which is the level that the labs are able to accurately achieve from 2 nationally certified labs CARES utilizes, can detect down to, is 1.0 milligrams per kilogram. Therefore, the labs would not be able to detect the Commission's proposed concentration. CARES collected 125 background samples for this metal, and 56 samples exceeded the proposed residential soil concentration standard, and 100% of the samples would exceed the protection of groundwater soil sample. Therefore, CARES requests that the concentration standard for chromium-6 be set to the PQL. Next slide, please. For naphthalene, the Commission's proposed concentration limit for the protection of groundwater of soil screening levels for this organic compound is 0.038. A lab that CARES and COGCC utilizes has a PQL of 0.02 milligrams per kilogram. Therefore, this lab would not be able to tack down to the Commission's proposed concentration standard. CARES requests that the concentration standard for naphthalene be set at the PQL, which is 0.02 milligrams per kilogram. Next slide, please. The USDA currently recommends a SAR concentration of less than 13. and the CSU Extension Office states that soils with a SAR concentration of less than 13 is desirable. Yet the Commission's proposed limit is less than 6, which nearly cuts in half the USDA recommended limit. Out of 124 background samples Caris has acquired, 16 of the samples exceeded the Commission's concentration standard. Additionally, Caris recently acquired native background soil samples from 3 commercial gravel pits that Caris was considering using as backfill for soil for a current remediation project. And the analysis showed that the majority of the samples had SAR concentrations greater than 12. SAR has been identified in Table 915-1 as the soil suitability standard for reclamation, not as a contaminant. Site reclamation is on the onus of the operator to achieve, and therefore many things that can negatively affect the successful reclamation of an oil and gas location. Caris's Piance asset has been able to achieve full site reclamation and bond release with successful revegetation on 88 sites, and Caris will be requesting closure on an additional 29 sites in 2021, with the current standard at 12. While the Commission has stated in the statement basis and purpose that based on hundreds of site closures, it was determined that the standard of less than 6 is appropriate to allow for revegetation, Caris does not believe this is appropriate or necessary for the Piance Basin operators. A SAR concentration of less than 6 has been identified as optimum for croplands such as corn, which are not prolific in western Colorado outside of Olathe. Caris requests that the concentration limit for SAR reflect the USDA recommendation of being less than 13 for non-croplands. Next slide, please. Naturally occurring levels of pH in the Piance Basin are considered alkaline. And based on extensive background sampling, Caris has determined that the range for pH is 6.4 to 9.7, with an average of 8.26. The Commission's proposed concentration maximum is 8.3. Recently, Caris acquired native background samples from a gravel pit that Caris was considering using as backfill for a current remediation project. And one gravel pit exceeded the pH of 8.3. Therefore, Caris believes a reasonable maximum for pH should reflect the native soils and be set at 9. Next slide, please. The Commission's proposed concentration limits for arsenic are 0.68 for residential screening levels and 0.29 milligrams per kilogram if a pathway to groundwater exists, which counters the conclusions that CDPHE derived based on a statewide assessment for background levels of arsenic, which was determined that the average background level for the state of Colorado is 11. Additionally, Caris acquired native background soils for arsenic, and the average in the Piance Basin is 9.97. Furthermore, samples acquired from produced water range from non-detectable to 0.0044 milligrams per liter. 3,384 background arsenic samples have been collected from Caris's Piance Basin asset for the purpose of closing facilities, pits, remediation, and releases to date. Caris has never been required to remediate drill cuttings or EMP impacted soils for arsenic, which has created a burdensome process requiring director approval, even though no arsenic impacts exist. Therefore, Caris does not believe that oil and gas operations contribute positively or negatively to arsenic levels, so it should be removed entirely from draft table 915-1. Next slide, please. In summary, Caris requests that the Commission consider implementing the proposed modifications to the components addressed in this testimony. Additionally, Caris requests imminent guidance for continued remediation efforts under Table 910-1 standard for ongoing abatement projects. Thank you. I will now turn it over to Dave Stewart with Crestone Peak.
Good afternoon, Commissioners. Thank you for hearing my testimony today. Crestone Peak Resources is a responsible operator that is leading efforts on continuous air quality monitoring, operational practices to reduce emissions and odors, as well as forward-thinking planning that reduces all types of environmental and societal impacts. We appreciate the opportunity to comment today. Next slide, please. There are two primary concerns that I would specifically like to address today. First, Crestone requests that the Commission clarify when a pathway for communication to groundwater exists for Table 915-1 and Rule 915A through issued guidance that is consistent with the CDPHE's guidance. Second, we suggest that COGCC consider eliminating the requirement in Rule 903D1E, which ties to Rule 405S, for a Form 42 Notice of Well Liquids Unloading 48 hours prior to a well liquid unloading's event. This requirement would add emissions rather than reduce them, and I'll explain later. Next slide, please. Creststone's primary concern is related to the determination of a pathway for communication to groundwater. Rule 915A provides overly broad discretion to the COGCC to determine pathway for communication to groundwater. My concern is this very low maximum contaminant levels, MCL standards, would be applied to sites that do not pose a risk to sensitive receptors such as drinking water aquifers, wetlands, or waterways. Determination of a pathway for communication to groundwater is complex, as each remediation site poses different types of soil lithology and groundwater fluctuations. Groundwater is ubiquitous as soils and ebbs and flows seasonally and regionally. Given this complexity, determination of a pathway for communication to groundwater is not a fast process, and as such will delay cleanup projects that it could otherwise be closed out in a standard time frame. The delay not only impacts the operator, but it would also lead to open excavation sites causing harm to surface owners and adding for greater potential harm to the environment in case of a precipitation event. Open excavation sites on a surface owner's property for extended periods of time would not allow for crops to be replanted and or the land returned to the owner for other uses. The potential for harm to the environment related to open excavation sites is related to stormwater runoff potential and expansion of the smear zone. Furthermore, a robust application of MCLs would impact the ability of operators to promptly plug and abandon wells. The pathway for communication to groundwater should be strictly applied only when the pathway is obvious and known. If the pathway is applied broadly, it will unduly burden the agency to manage many complex remediation projects, delay remediation, and delay the proper abandonment of wells. Next slide, please. We asked that the Commission provide guidance to COGC staff to initiate a short stakeholder process with operators to develop specific triggers for determination of pathways for communication to groundwater in a guidance document format. Furthermore, we request the collection of groundwater data is only required when visual impacts are observed and confirmed through analytical analysis, which we will develop during the stakeholder process with COGC staff. If it can be conclusively demonstrated that all contaminants of concern are above the water table and do not have the potential to impact groundwater, then sampling of the groundwater should not be required. Lastly, I suggest the Commission remain consistent with the CDPHE and refer to the recent guidance provided by the CDPHE when developing the COGCC guidance document. The title of the CDPHE document is The Change to the Use of the U.S. Environmental Protection Agency Regional Screening Levels as the Primary Remedial Objectives for Air, Soil, and Groundwater. Next slide, please. The second concern held by several operators is related to the Form 42 Notice of Well Liquids Unloading Events and its unintended consequence of increasing emissions. The Commission could consider eliminating this requirement. In Rule 903D1E, which ties to Rule 405S, because a 48-hour notice, pre-notice would increase emissions. Well liquids unloading events typically are a reaction to well performance problems, such as declining production, and often occurs quickly. Therefore, they're difficult to predict ahead of time. If the well would have to be shut in for 48 hours to make this notification, the well then may not unload. This may then require the operator to swab the well with a workover rig, which involves bringing in a workover rig powered by diesel engines to run pipe down the well tubing to pull liquids out until the well bore is cleared. Swabbing the well will be much more intensive from an emission standpoint than the immediate unloading event. You could see 4 to 10 times as much emissions due to this requirement from this type of operation. Unloading events are highly documented, and emissions from the reported to CDPHE through the Reg 7 requirements. Industry suggests that the Commission remove this requirement to avoid unnecessary emissions and to acknowledge that the COGCC can access information related to well liquids unloading events from the CDPHE data. Next slide. In conclusion, we respectfully request that the Commission further define pathways for communication to groundwater through staff guidance and be consistent with CDPHE guidance. And also we ask that you eliminate the pre-notice requirement for well liquids unloading. Crestone appreciates the opportunity to comment, looks forward to continued collaboration with the Commission and COGCC staff on developing rules and requirements. This concludes the industry presentation. We are now open for questions. Thank you.
Okay, great. Thank you all for your presentations. Commissioners, I believe now we have an opportunity for questions. Commissioner McGowan.
Thank you, Mr. Chair. Thanks for the science lesson number 6. So I have a lot of questions. So I'm going to start with the table 915 and some of the comments about background levels and detection levels by labs. My understanding is that we added some footnotes to the table that allow for consideration, and hopefully staff is around to help me out with this because I asked our staff a lot of questions about this. There are some footnotes that allow for some accommodation around background levels and detection levels by labs, and I'm wondering if you have seen the footnotes and if that makes some of these issues more workable.
Yeah, so I think it's footnote 1 and 11 both indicate that you can use background concentrations in order to achieve compliance. Some of the issue we have is part where we have the arsenic problem, and we're allowed to do that currently with arsenic. However, that's where the 3,300 samples have come from, is trying to generate data in order to indicate that we are meeting background concentrations. And then some of the ones that we have with, chromium and naphthalene, they're at such a low level where the lab can't detect them. And if we're hitting a point where the lab can't meet the concentration, it's extremely difficult to try to get closure on a site, and we have to work back and forth with the EPS in order to achieve that. Hope I answered your question.
And Commissioner McGowan, let me lay some ground rules. This is a really large panel, and some of you do not have video capability, so it would be difficult for me to see you and raise your hand, but we do need to create a record. So whomever is answering, can you say your name first to the question, and then that way we can create a record without me getting in the way. So let's give that a shot. That was Brett Middleton. And now Commissioner McGowan, you still have the floor, and you can continue to ask questions until you're done.
Thank you, Mr. Chair. So again, I'm probably gonna mess this up in a huge way. In talking with staff, the lab detection issue was such that if the lab is unable to detect to the level that's in table 915, if the lab does detect, the assumption will be that you have not met the standard. And so just because the lab isn't going to be able to detect it, we're going to accept the level that the lab does detect it at. We'll accept that level and then use it for meeting the table 915 standard. And so I'm unsure whether or not, again, I'm just not sure this is still a problem based on your testimony.
This is Brett Middleton. I'll speak on that again. Yes, we did notice that also in the footnotes. And I think one of the issues that we worry about is frequently in the lab you have detection limits that are set. And a lot of times with the lab, they'll have to use a dilution factor that comes in. And if we have a dilution factor that's used, the standard can vary over time. So it can be 0.02 for one particular sample, and the following sample could be 20 at that point because of the dilution factor that kicks in. There's not a lot of clear guidance on if the 0.02 would work as far as being a BDL, or if the less than 0.200 would be effective, or less than 0.20. There's just some clarity I think that needs to happen, maybe with the guidance.
Okay, so you think that you all could maybe work through some of that with staff through a guidance document?
Yeah, I think we probably could. I think I think without some guidance, it's going to create questions down the road, and there's going to be unclarity whether or not a project could actually close and whether or not you're going to be able to achieve remediation.
Thank you.
Thank you.
To the arsenic issue, and perhaps Commissioner Putnam can help me here because I know enough to be dangerous. I think from a health perspective, you might be pulling something up from the ground that will be lower than the background level for which you want to put it into. And I'm using water as an example. And those water segments, in some instances, the arsenic level is not protective of health. So even though what you pulled up was below what's in the background level in the water, we don't want you adding to the water because the water already has an arsenic issue. I am uncertain if soil has the same type of issue, but in that instance, there's a reason that we don't want you adding more arsenic to something, even though the background level that exists is higher than what you pulled from somewhere else that you want to add to an existing space. And so I would like to know if that is the situation we have with soil and arsenic. And I hope that that made sense, what I just said, and I hope that it was halfway correct.
Yeah, this is Brett Middleton again. It did make sense. And I think the part I would speak on that is when it comes to soils, we have to always sample for arsenic in order to meet current 9-table-1 within the rules. And to date, I have yet to do a remediation where we have an arsenic issue. Arsenic has always fallen below the background concentration. So what it ends up creating is just some undue burden on the operator to do a bunch of additional sampling in order to prove that we're meeting a standard that's probably set entirely too low based on current state background levels.
Thank you. Do you, when you do sampling, do you sample separately for arsenic, or do you turn in a soil sample and ask for a panel to be sampled for many different things to meet standards and requirements?
Yeah, this is Brett Middleton again. So if we're sampling in an area that we're trying to achieve compliance on location, say for instance, if there was a spill or release, we would be doing the entire 910 panel unless we've gotten director approval to reduce that panel. The arsenic samples we take as background outside the location typically are arsenic specific only. And we'll typically do multiple samples on a location.
Thank you. And then I'm going to switch directions. I'm wondering if any commissioners want to talk about the table, because I'm done asking questions about the table, Mr. Chair, and then I can come back to other questions.
No, I think that makes sense. There's a lot here. Do other commissioners? Okay, Commissioner Putnam has a question about the table.
I just wanted to thank you, Mr. Chair, and thank you, Commissioner McGowan. I just wanted to respond to your prompt just asking the question. I know that COGCC staff and hazardous waste and waste management division staff work very hard to coordinate the work on that table. And so as a result, they sent the letter of support that I think you all saw late last week. I think if there are further questions on that, we can make sure that they're available during kind of final questions to staff. But I think they're pretty comfortable with the coordination of those and making sure that division and commission procedures are consistent.
Other questions from commissioners about the table? Commissioner McGowan?
Sorry, I said I was done and I lied. So I have to tell you, I'm having a little trouble understanding the TPH issue and the additional, the addition of the carbon screening. And if I can try to summarize what I think I heard, and if you could help me, that I would be appreciative. It sounds to me like there's concern that the levels that, based on what's been added, the levels were unsure, the industry is unsure why we've set the levels at the level that we've set them. What is the scientific background for it? And how is it protective? And I think that you all were pointing to health, and I don't know if it also has an environmental purpose as well. And And so I might need some help or a phone a friend with staff to maybe address how we came up with those levels and why we added the additional carbon range. And maybe that's not today, maybe it's as we're deliberating, going through things, but at minimum, I need to put in a parking lot because I'm not sure I understand.
And I also would sort of echo that question and would potentially ask our Assistant Attorney General Minor to help us understand this situation and also help us understand when the 500 milligram was first adopted. If you could weigh in on that, and then perhaps the witness can weigh back in on that as well.
Certainly. Thank you, Mr. Chair. So with respect to Dr. Ryman, I think that her presentation may have blurred the line a little bit about what changed in the rules. So the 500 milligrams per kilogram TPH limit that she referenced, that was adopted in 2008 and remains unchanged in this rulemaking. As I understand, there's a fairly solid basis for that decision in the 2008 rulemaking record, and that was based on both health concerns and some sort of other concerns that come up in the reclamation process. It wasn't a purely health-based decision. Dr. Ryman was correct that staff have proposed to expand the carbon range that is included within TPH in this rulemaking, so that we did not change the 500 milligrams per kilogram limit, but we did expand the range of hydrocarbons, I believe, up to C36. I think it was previously C28. I may have had that wrong. And if we have Dr. Gentaudis in the Zoom, he should be able to provide a little more background on why staff made that change, if there are further commissioner questions about that.
Well, I guess my question is, Dr. Ryman, why did your slide say that the TPH was changed when it's been the same since 2008?
It was my understanding that it was a proposed change.
Okay, well, that's
regardless
a fair way of saying that.
Regardless of whether it is changed or not, when one compares this 500 milligram per kilogram screening level to the values that are used by the U.S. Environmental Protection Agency, as described in my written testimony, there are instances when sites, when you have sites that are heavily contaminated with some types of TPH that have RSLs below 500 milligrams per kilogram, this value is not going to be protective. They're also going, also if you have instances in which sites are heavily contaminated with higher range TPH, it's going to be overdoing it. It's not going to be reasonable. And so it's a little, it's my understanding that for other contaminants in that table, the commission is proposing to use EPA RSLs. So it's a little striking to me that in comparing this value to EPA RSLs, that I've noticed instances in which the level falls short, and then instances in which it's unreasonable in terms of human health protection.
Commissioner Messner.
Thank you, Mr. Chair, and thank you, AAG Minor, for clearing up the fact that this wasn't actually a change. I did have a question, though, for Dr. Ryan regarding, I mean, you continue to use the terminology that it is health protective without being unreasonable.
Mm-hmm.
And so I guess I'm struggling to understand, in your opinion, what's reasonable or unreasonable as far as the protection of health.
Right. So, and this is described in greater detail in the written testimony. So when EPA derives their RSLs, they do that on a risk. It's on a risk basis. Okay, they consider both hazard information, and they consider, i.e., the toxicity value, and they consider exposure information in order to come up with a health protective RSL. So, and some of those RSLs are very large. Okay, so for example, I think it's for high range. It's in my written testimony for high range aliphatic TPH. I think the value is something like 230,000 if you're using a hazard quotient of 1, and I think it's 23,000 if you use a hazard quotient of 0.1. Well, your value is 500. So if you divide, 23,000, even if you use the hazard quotient of 0.1, as y'all were proposing to do, if I divide 23,000 by 500, I get a value of 46. I mean, in that particular case, your value would be 46 times in excess of what it needs to be. So that's what I mean by unreasonable. It would be 46 times in excess of what EPA says it needs to be. That's what I mean by unreasonable. Because EPA's values are risk-based. And again, I don't know what the basis is for your 500.
Well, maybe we could get an answer to that, what our basis is for the 500.
AAG Minor, or I think I saw Dr. Quintanas.
Mr. Chair, I believe that Dr. Gantautas and Mr. Duranlo are both prepared to answer that question and can speak to some of the factors that the Commission considered when it adopted the 500 milligrams per kilogram standard in 2008. I think maybe we can start with Mr. Duranlo for the broad strokes and then turn it over to Dr. Gantautas if that works.
Mr. Duranlo.
Thank you, and thanks for the opportunity to hopefully provide some clarity. So as AAG Minor mentioned, in 2008, when the standard was adopted, it was changed from a cleanup standard for TPH of 1,000 in sensitive areas and 10,000 milligrams per kilogram outside of sensitive areas. One of the primary reasons for that, it's not necessarily a health-based standard. We are regulating to protect public health, safety, welfare, the environment, and wildlife resources. So just looking at that as a health standard doesn't paint the whole picture of leaving oily soil in place at a site. And we frequently responded to complaints of oily goo, piles of oily soil, residual in fields on private property. And lo and behold, those might very well have met that 10,000 TPH standard. And so it was appropriate at the time to reduce that standard to 500 milligrams per kilogram. And I think it's certainly appropriate to move forward with that standard. As far as the carbon ranges specifically, that's where I would turn it over to Dr. Quintanas if he wants to add any information as to the carbon ranges.
Dr. Quintanas.
Thank you, Greg. There really isn't a change in the carbon ranges. We've never specified a range. We simply said TPH. And I called it out in there as certain numbers simply to provide more information to operators about what they might need to do to realistically quantify crude hydrocarbons that are present in soil. We see crude oils that go up to C44 in chain length. I didn't put that in because that's pretty rare, and it also, it's not many oils. There are many oils in eastern Colorado that are. We have oftentimes received and asked for things that got out to C38 from many operators. So this really is not a change. I just wrote out what numbers that we wanted so that it wasn't missing from the rule itself, that we had to explain it every time to people. The range that's been mentioned is what's called diesel range organics. That doesn't encompass much of what's in crude oil, which is what's spilled in certain parts of Colorado.
And that's exactly it. The range that's specified is trying to get at the range of contaminants that we're seeing at oil and gas locations and what we intend to use that TPH standard for. So, thank you.
Those two things at the top of the table are both general clauses. The one about visible, observable liquid hydrocarbons in water or soil, that simply comes from, say, NIPD's permits, where you always look for oil and grease on the discharge. Not something complicated, and neither is the 500. It simply is a number to help us get to soils that, you know, both are clean and look clean. The 10,000 in the old rule was based on agricultural things, and then no way was a health or anything else. 10,000 TPH in a soil is a black goo, and it won't let plants grow because it eats up all the oxygen, and the root zone doesn't do well. So partly that's a reclamation process too, why it got lowered to something less than 10,000. And the 500 was a number from 10 years ago that it was argued out in that rule. And I can't tell you, I've read the statement of basis and purpose recently, but it was not, you know, met with much, there were some concerns about it. People wanted the 10,000, and it simply was not a workable number for reclamation.
And Mr. Chair, we do not mean for staff to take over industry's presentation. Certainly we can answer any further questions that that you and the other commissioners have about this topic.
Yeah, not a problem. And I think it is helpful to get perspective as the commissioners debate or take information on this topic. Let me turn it back to commissioners. Are there other questions with regard to this issue and or the 915 table? Commissioner Gonzalez.
Thank you, Mr. Chair. Yeah, I just want to piggyback on something that I think it was Mr. Geronimo, maybe been Dr. Quintanas, who mentioned, who basically said they base this range, new range in these rules on what they've seen at oil and gas locations. Is that the reason why they chose that over the EPA standards that that a couple of the industry experts have suggested in their testimony today? I want to address that question.
This is Peter Gintatis again. I will. We did look at those numbers, and there is not adequate analytical methods produced by consensus or EPA organizations to do that test. And I believe if it was done, instead of, say, the test for 500 TPH might come to $100, I believe the test for the multiple ranges and doing all that, people are paying somewhere in the $1,000 to $1,500 per sample. There oftentimes are 30 or 40 samples done in an excavation. This is a cost-effective way of getting us to low numbers. Plus, in real life, we have the benzene standard, the toluene, xylene, PAH standards, and we apply those too. And those are what lead to the toxicity in general in the lower hydrocarbons. So we have standards specifically for them. Plus, we have a general clause standard for the 500 milligrams per kilogram.
Mr. Martin, you have unmuted. Was that accidental, or did you want to weigh in on this issue?
This might be a massive mistake on my part, because I am not an expert, and I'll try to ask a leading question of Dr. Rasmussen. But I think the fundamental issue that we're trying to emphasize is that a one-size-fits-all 500 milligrams per kilogram standard is not the EPA standard, and that is not the Hazardous Materials Waste Management Division standard. And beyond that, a default value of 0.01 as opposed to 1.0, again, is a divergence from the EPA standard, and something that also is of some concern to us. And again, it's also something that the Department of Public Health and Environment noted in their support letters, that it is not the default value that they use. So we're principally trying to sort out what is the basis, and I'll turn this over to Dr. Rasmussen, but what is the basis for a one-size-fits-all 500 milligram per kilogram default value hazardous exposant ratio of 0.01 as opposed to 1.0. We just don't see the evidence for it. We'd like to understand it better to get a sense of where this is coming from and what its goal might be. Was that enough of a leading question, Dr. Rasmussen?
Dr. Rasmussen, would you like to answer your attorney's leading question that predicted an answer for us?
Well, sure. I'll be happy to answer the question. I mean, yeah, that is the, you know, essentially the main point of my testimony is, you know, compared to US EPA RSLs, there are instances in which the 500 milligram per kilogram value, depending on the site, isn't going to be protective and of health, and then instances in which it's going to be overdoing it. And so, you know, now that we have, since we have these federal standards, I mean, it really, you know, I think it kind of begs the question of where did this 500 value come from, and why is it a flat one-size-fits-all value when there are EPA standards available, particularly when there can be instances in which this 500 milligram per kilogram value isn't going to be health protective.
Thank you for that additional testimony. Commissioner Gonzalez, the floor was yours. Did you have further questions on this?
I'm curious if the EPA standards create more of a flexible regime that maybe I'm not understanding versus kind of this catch-all 500 level. That's and I'm afraid, you know, we're adjudicating something here that's already been in the existing rules, and I'm really trying to get an understanding here because, you know, speaking for myself, you know, not being a scientist in that regard, I really want to make sure that we understand this before we move on.
Yeah, sure. This is Jessica Ryman Rasmussen. So, and this is in my written testimony too. So if you have to go back and look it up, you can go back and look it up. But EPA actually divides the TPH into 6 fractions. So they break them down based on carbon chain length. So that's low, medium, and high range. And then they also break them down based on whether or not they're aliphatic, which essentially means like a straight chain carbon, or aromatic, which means they have rings, okay? So for each of those 3, low, medium, and high, there's aromatic and aliphatic. So there's a total of 6, all right? And for each of those 6, essentially what they do is that they find representative chemicals of TPH in that range. And it is from there that they derive something that's called toxicity values, which consider the dose response of those representative chemicals, and that also consider uncertainty in scientific studies, okay, like extrapolation from animals to humans, or variability within the human population, database uncertainties, et cetera, okay? And from there, they get a number called the toxicity value. And EPA then combines that toxicity value with information on exposure in order to derive an RSL based on risk. And so when you look at each of those RSLs, which are in exhibits B1 and B2, you can see that there's a range in the magnitude of what those values are for soil, for inhalation, and then also overall. So they're really very broad, and that broad range of what the magnitudes of the RSLs are reflects the very large differences in both toxicity and the amount of exposure that is anticipated based on different scenarios. So this is a broad category of chemicals with a broad range of use patterns, and to try to capture it all in a flat value of 500 is tough to do. Maybe not very possible to do. And so that's why, you know, even for the hazard quotients and whatnot, based on the site, that's why the ability to tailor this stuff to the site is provided for by EPA, so that we don't, so that we can be more accurate, so that we can put a finer point on it, so that we can tailor it to the situation. Does that answer the question?
It's a deeper level of understanding than I had when I asked that question. So I appreciate this. I think it's going to
Yeah,
be
it's in the written testimony. Yeah.
I'm sorry?
Oh, I was just going to say, I'm sorry to interrupt. It's in the written testimony. Look, this stuff is complicated, okay? It's really, it's not easy to wrap your mind around, and then it's easy, and then it's also difficult to try to explain to people. But this information's it's in the written testimony as well. But yeah, this is not an easy thing. This is not an easy thing to do. This is really complicated.
Yeah, and I appreciate the answer, the explanation, the testimony. I understand the concerns, you know, with the application of TPH, and I think that what might help connect it a little bit better with maybe some more clarity, and perhaps this is for Mr. Middleton, maybe a different witness, is what's the effect on operators of having a, you know, the approach as currently stands.
Yeah, I can try to answer that. So this is Brett Middleton. So what we've got right now with TPH is we've been sampling to the TPH GRO and DRO. The way that works out is you do analysis of both TPH GRO, DRO, they get added together. That additive result is your standard, which is 500. By throwing in the C28 to C36, it's basically adding in the OSOs, which now it's, you know, if we had, I'm just going to use an example here. Say we had 100 on GRO and 395 on DRO, our result will come in at 495, which would be a compliant. If we add the OSO in there and that comes in at say 35, we've now exceeded COGCC 915 rule. And I think that's the difficulty for operators where we're going to struggle, is it's adding an additional layer of sampling for us to try to comply with based on a standard that we've currently been complying with. And, you know, the 500 is a low standard. It's lower than most states, but it's been achievable in the state of Colorado. I think we've done it as operators fairly significantly. But adding that OSO to it is going to add a layer of complexity that is going to require additional remediation, likely on a remediation site. Hope that answered your question.
Thank you, Mr. Middleton, and thank you, Doctor. I think that's it for me for this particular portion.
Commissioner McGowan.
Mr. Chair, I just want to make sure, I have a feeling we're going to have to circle back around to this and see if we can straighten some things out. But I also want to point out what I think I heard Dr. Quintana say, which is the standard was also set based on plant productivity and what a plant can grow in or not grow in. And so I just want to make sure, I think what we're talking about in this discussion here is a health-based standard, but it sounds to me like we're also, when we were looking at the standard, we're thinking about plants as well. So I just want to make sure that that doesn't get lost in the conversation, if I understood Dr. Quintana's correctly.
Okay. Any further questions on this topic? Otherwise, we can move to other topics from the industry testimony. Commissioner Nanjapa.
Thank you, Mr. Chair. Sorry, and more just kind of following up on as Commissioner McGowan commented, I wanted to also note, because I think Mr. Martin maybe raised the point of what was noted in the CDPHE comments. And what they did say as well is that there was an understanding that COGCC based their decision to use a hazard quotient of 0.1 on the US EPA recommendation that the use of a THQ of 0.1 is appropriate when more than one compound of concern is likely to be present. And so I think that's another piece of all of this that I just want to make sure it also doesn't get lost in the discussion. Thank you.
Okay.
Is that something I could? Oh.
Sure, go ahead.
This
State
is
your
just Ryman Rasmussen. If I could, I would like to respond to that. In my written comments, that I do acknowledge that. I note that I then go on to cite in EPA's online information, some sections of the information that they provide that indicates that that's a very general statement, but that in the area of the RSL information that I cite in the written testimony, there are it's possible to drill down further from that general statement and note that EPA does provide provisions using a hazard quotient of 1.0 as a default. They provide provisions in that guidance where, based on the composition of the chemical contamination at that site, depending upon the type of risk assessment and so on and so forth that's going to be done, that the value can be modified. So that statement of 0.1 when there's more than one chemical is a general statement, but it's possible to drill down and put a finer point on it, going to other parts of the EPA information. So there's more regarding that in the testimony.
Thank you. Commissioner McGowan.
Thank you, Mr. Chair. I'd like to jump over to pits and the comments about the 2 tons per year and the 5 tons per year. We had talked about this a little bit before yesterday, I think during the comment period, about how staff came up with the 2 tons and the 5 tons. And I think what I heard Mr. Colglazer say was that some of these tons per year might not be attainable, and I'm wondering if I'm understanding that correctly.
Thank you, Commissioner McGowan. And I did not hear the comment session yesterday afternoon, so I apologize if I missed that information. But the concern is that there are not very many control technologies available. And so for these large produced water ponds, which can be 100 or 200 feet on a side, holding up to hundreds of thousands of barrels, not gallons, but barrels of water, your emissions can depend primarily on the throughput and the volume of water that you need to store. But that is the purpose of the pond, is to store water for recycling. So you can do some things. You can run the water through a tank. You can try to separate and recover hydrocarbons before it's put into the pond, and that is commonly done. It makes economic sense. You want to recover those hydrocarbons anyway, and that reduces emissions. After that, it's difficult to control because the ponds are just so big and the hydrocarbons evaporate from the water.
Commissioner McGowan.
So this is not a trick question, but I'm just curious, how many ponds do you think are emitting more than the 5 tons per year right now that would have trouble with this limitation? Like on a percentage basis, are most ponds, I'm trying to figure out how big this problem is, sorry.
I think we can try to get that answer. I don't know what that answer would be, but 2 tons or 5 tons per year is pretty low. Yeah, I'll leave it there. We can try to get that information unless someone else has it.
Could I jump in just a little bit? I think one point of note is that these facilities are permitted heavily by the Air Quality Control Commission. They perform what's called a reasonably achievable control technology analysis to get those permits. And to Chris's point, they often go through processes, that's really the entire intent of the facility, to get these pond emissions as low as possible. And that is heavily regulated by the commission. When we talked with our members, particularly on the West Slope, there are about 8 facilities that would be impacted by this becoming retroactive. However, that's just our members, and I don't think that's 8 ponds, that's 8 facilities. But to Chris's point, we certainly could do some more research. But I just wanted to highlight that these are regulated, these emissions are regulated, they're monitored, they're reported, and that's actively done through the Air Quality Control Commission.
And that was Christy Woodward for the record.
Thank you, Commissioner Robbins.
Commissioner McGowan, please.
Sorry, just keep going. This is also not a trick question, but there have been a lot of comments from stakeholders and yesterday during the public comment that there should be no venting or flaring allowed unless it was an emergency type of situation in general. And I am wondering, is it technologically feasible to have zero emissions except during an emergency? And I'm wondering if you could address that, please.
Who wants to take that one up?
This is Chris Colglazer for COGA, but certainly if Jen or others want to weigh in, feel free. I think the short answer is no, it's not technologically feasible for these sites to operate with zero emissions on a regular basis. And when some parties have said they want to see no venting or flaring allowed, I think that is what they mean, is no emissions, whether those are characterized as venting or flaring or something else. Certainly there have been a number of emission reduction strategies put in place and more will follow, but no emissions is pretty strict.
Thank you for that question and for that answer. That is helpful. I think I saw Commissioner Messner, then Gonzalez, and then Joppa.
Thank you, Mr. Chair. I do have a follow-up to that question because this has been something that I've been reading about, listening about, and this is my opportunity to ask you guys this question. So, Mr. Colglazer, you talked about in your testimony some concerns about some of the testimony that we've heard around the desire to see a reduction in permits in order to be able to meet certain greenhouse gas emission goals. I certainly understand from an industry perspective that that would be a concerning concept to look at. And so I appreciate that concern and you expressing that concern and that opposition to that testimony. On the other end of things, though, some of the testimony that you provided and some of the written testimony from different industry groups seems to continue to look for additional exemptions, exceptions to different flaring and venting regulations that would, in theory, allow for additional emissions to be generated from operations around the state, which seems to go backwards as far as what the ultimate goal would be, which would be to not have to reduce the number of permits in order to be able to meet greenhouse gas emission goals, but rather utilize technology, best management practices, and minimization of these exceptions in order to be able to meet those so as not to negatively impact operations and industry. So maybe you can help me understand that dynamic.
Yeah, thank you, Commissioner Messner. And again, this is Chris Colglazer for COGA. I guess I would say two things. First is about your question about the exemptions or rule changes that we're looking for. And second, I'll give you an overall perspective on what the statute calls for with GHG reductions. But first, for the exceptions, we are not here arguing that this industry should not be regulated. We're not trying to oppose the rules on venting and flaring. We've supported additional restrictions on venting and flaring. So I think we're here at the table, we're working constructively. We're trying to find ways to make sure that the rules are something that can be implemented. So for example, a couple of the things that we asked for, looking at emissions from an on-site compressor or an on-site glycol dehydrator that is helping to move the natural gas from the high pressure inlet separator to the sales line. These are pieces of equipment that you need. Maybe your pressure from the well is high enough you don't need a compressor, but it's not uncommon to have an on-site compressor in order to push that gas into the pipeline and move it to the market. That compressor has equipment, it's designed to minimize emissions. It has seals, for example, around the chamber where the gas is flowing through. It has a seal to hold that gas in place. But those seals are only so good. They're good, but maybe they have a blow-by rate of 1 or 2%. So that gas that makes it through the seal has to be captured, and you have to do something with it. It's not at a pressure that is high enough to put into sales. It's a small amount, and so it really makes the most sense to just burn that gas. And so we're not trying to avoid a requirement. We're trying to look at the existing Air Commission rules that require you to capture these vapors from the seal and control them, and just make sure that this COGCC rule is consistent with that. And I think that's true with really all of the requests that we were making for these regulations. We're not trying to say don't regulate this industry or let them emit by any stretch. We're making sort of targeted technical changes to ensure it can work, and that's what we're looking for with the guidance that we're seeking. On the other question about our concerns of the request by some parties to curtail production, I would say first that that is not what 1261 or 181 tell this commission to do. 181 directs you to regulate emissions, to regulate this industry to protect public health, safety, welfare, and the environment. Regulation is different than curtailment or blocking an activity. And related to that, 1261 sets GHG reduction goals for emissions within the state of Colorado. 1261 does not set GHG reduction goals for the consumption or use of oil or coal or any fossil fuels that may be produced in the state of Colorado. It is simply silent as to that. And so asking to cap production as a way to reduce national or global GHG emissions, apart from not being effective because it's a global supply, apart from not being effective, it's really outside the scope of the statute and pretty legally questionable whether that is something that you could do. Now, if the desire is to cap production as a way to limit production emissions, that's not as far out on a limb in terms of what the statute directs you to do, but there are simply better ways to reduce production emissions. And even just on Friday, the Air Pollution Control Division staff expressed that they believe that the targets for this sector, which are more aggressive than the 1261 statewide targets, are appropriate and can be met without production limits. So I don't know if any others want to chime in if I missed anything on that answer.
Any follow-up, Commissioner Messner?
I don't have follow-up on that particular question, so thank you for that.
Thank you.
Let's go to Commissioner Nanjapa.
Thank you, Mr. Chair. I do have a follow-up on that sort of line of questioning. And thank you all for your testimony today and explanations on the various questions so far. I'm going to ask some questions that are clearly because I don't fully understand how these things work, and I want to better understand the reasons for certain things being possible or not possible. So you mentioned, per Commissioner McGowan's question, that it's not possible to operate in a zero emission state with current technology. Although you did mention that even if you could capture what is coming off of the dehydrators and the compressors, it would not be sufficient to push towards sale. Is there a way to capture it, though, so that it is not being emitted?
Yes, Commissioner Joppa, thank you. And again, it's Chris Colglazer. Those emissions are captured. So there is a vapor collection system that is on the compressor or on the reboiler for the dehydrator, and it's similar for the other pieces of equipment. There are extensive regulations in place that require those emissions to be captured or controlled where it's feasible. And I would say that those rules have been intentionally designed and written through a stakeholder process like this one, where the Air Commission and the staff who have expertise in these areas has spent literally years looking at those emissions and trying to identify what can be done, what is realistic, and putting rules in place.
Thank you, Mr. Colglazer. And I have a few more follow-ups on this line, Mr. Chair. Thank you. Okay, so I appreciate that response. And then I know you did respond a little bit to Dr. McCabe's testimony earlier about being able to capture in some cases from the tanks where there is where some flaring occurs and there's a potential for vapor capture, and that is occurring in the DJ Basin. I was curious if you could help me understand, anybody on the panel, you know, why, if that is occurring in certain places, is there any reason that could not occur more generally, that ability to capture more of that vapor from those tanks? And if that's the same response as what you just provided regarding the compressors and dehydrators, then you know, let me know. But I'm in my understanding is that's a different type of venting that is occurring there, and the flaring that's required to combust that.
Yes, and thank you again, Commissioner Chris Colglazer, one more time. Let me start, and then I think Jen Beaver may also want to weigh in on this same topic. I think first, it's important to just look at the level of the emissions. And while I don't have these numbers in front of me, I'll just react a little bit to some of the numbers that Mr. McCabe put up about the emissions from storage tanks versus emissions from the high pressure separators. And he said that the reason emissions from storage tanks are higher is because they have not been scrutinized. And I really just have to disagree with that. Emissions from storage tanks have been probably the single largest emissions point that the Air Quality Control Commission has regulated since about 2005. They've had multiple rulemakings to look at emissions from tanks, and reducing tank emissions has been a primary focus of how they're trying to attain ozone standards within the non-attainment area as well as through the rest of the state. I would say the reason that emissions from the natural gas sales line or from the separator are lower is because Colorado has a good gathering system in place, and operators have just done a good job of capturing that natural gas and sending it to sales. And so we're not in the position of some other states where there's kind of a boom and people are drilling faster than the gathering infrastructure can be built. And so we've just done a really good job on both fronts, honestly. But there are challenges associated with capturing emissions from the tank. There was some discussion this morning about using a vapor recovery unit to capture those emissions. VRUs are used at oil and gas production facilities, not necessarily on the tanks. And there are potentially some safety concerns with the tanks. And I think Jen probably has some thoughts that she wants to share on how these VRUs can be used at tanks.
Thank you, Jennifer Beaver on behalf of Great Western. So first, I think there might be, at least from my perspective, some confusion with respect to the VRUs and the number of VRUs that Dr. McCabe mentioned, and I'll kind of get to that. But with respect to VRUs, like vapor recovery units, which recovers the gas from a variety of different things. So you saw on Chris's diagram today that VRUs are used off of the separator equipment as well. So they take that gas and they compress it to get it into the sales line. Part of the problem is that you cannot introduce oxygen into the sales line, otherwise it creates significant issues with like corrosion in the pipelines and the gathering systems. So it's really critical that oxygen doesn't get introduced into the sales line. And in fact, gas with too high of oxygen levels will prevent operators from sending gas to the sales line. On tanks, you have, the use of vapor recovery units on storage tanks creates a significant risk that oxygen can be introduced into the sales line. And part of the reason for that is that tanks are at atmospheric pressure. So, you sort of heard some today about the separators, and that separator equipment is under some level of pressure. By the time the liquids get to the tanks, they're not under pressure anymore. They're at atmospheric pressure. And so, when you hear, when you saw in the statement of basis and purpose reference to like working and breathing losses and flash gas that's coming off that liquid, that is what is coming from the tanks. And part of that working and breathing means that air from the atmosphere gets pulled into that tank as part of that natural process. So with that air comes oxygen, right? And so, vapor recovery units are essentially compressors that are used to push lower pressure gas into the sales line. And so when you draw emissions from storage tanks, vapor recovery units could introduce oxygen into the system unless that oxygen is removed. So I think you have two issues with routinely using VRUs on storage tanks. One, is there enough gas actually coming from the tanks to run the VRU into the sales line? And that's not always the case. And second, can you remove the oxygen before going to the VRU? And that's a really complicated process. It doesn't work at all facilities. There are limited mechanisms for removing oxygen, and they can't consistently be used in all or even a majority of circumstances. So when he mentioned that, thousands of VRUs, I think we expect that is respect to VRUs coming off of separation equipment mostly, and we expect that the number of VRUs, while there are some instances where they are used and can be used on storage tanks, is a much, much lower number. And I guess I would also just note that, a VRU, a compressor, has to be run by an engine. So it has to have power. And some of those engines themselves may have their own emissions, which then offset some of the emissions you're saving. So, I would just reiterate what Chris said, which is, the commission and the division have been looking at tanks for a long time. They're well aware of, vapor recovery units. There's definitely discussion around them. And there's capture and control of these storage tanks in a way that, they are very heavily regulated. So hopefully that helps some.
Yes, thank you very much. I appreciate that, that additional explanation, Ms. Beaver. And I had just a couple of additional questions. So one, related to what Mr. Colglazer, you were mentioning that, you've done a good job in the gas capture lines. But as we've been discussing with the rules, there's obviously a lot of operators or sites where we don't have the gas capture lines in place yet. You kind of alluded to, because of the boom that has happened, that it hasn't kept up. But I was curious if you or others could comment on that progress. Is that happening in sites, knowing that this was kind of on the horizon? What's the level of progress? How difficult would it be to get to full gas capture line compliance? Or maybe compliance is not the right word, but to get to that point for all of our sites, what does that sort of overall picture look like?
Thank you, Commissioner Njapa. And once again, Chris Colglazer, and maybe I'll start, and I don't know if Christy or others will want to weigh in. But first, when I mentioned a boom where development outpaces the capture infrastructure, that is not in Colorado. I'm talking about other states. North Dakota experienced this about 10 or 15 years ago, where they just drilled so quickly in the Bakken that they didn't have the infrastructure. I think you're seeing it to some extent in the Permian Basin as well, where development is happening very quickly. Production has increased here, but it's a more compact field in the DJ Basin, and in the Piceance, it's a gas play, so people are targeting the gas, and they're not looking to allow that gas to escape. And so the level of flaring or venting in Colorado is exceedingly small. I know Katie had some numbers earlier. I don't have them at the tip of my fingertips, but certainly less than 0.25% per year. So I would not agree that we have a large number of facilities that are not connected to gathering. I think it's a very limited number of facilities where that happens here in the state, and really we should be proud of what we've done. So I'll stop there.
I do have those numbers handy if you would like to hear them. In 2015, 0.04% of gas produced was flared. And then in 2016, 0.8%. And then in 2017, it was 0.1%, 2018, 0.25%, and then in 2019, 0.2%. So really 99.8% of all gas produced in this state went to a pipeline and was sold in 2019. So I think that's a long, that's a good history and record of, gas getting to sales in this state.
Thank you.
Thank you so much. Appreciate that additional information and clarification of what the picture looks like here in Colorado. It sounds like because there aren't that many facilities that do not have the gas capture lines available, that the time frame that we are proposing should be reasonable. And I would invite any comment on that if people would like to comment on that. I would also just for a last question, was curious if the venting or flaring could be done at, could be done with timing restrictions. So obviously in our hottest days of the summer, and when we have air quality issues for other reasons or wildfires or other things that are going on, as we've all experienced this summer, is there any way that we could limit the venting or flaring that is necessary for some reason or another to other times of the year when it would be less impactful?
Yeah, Commissioner Najapa, this is for Stewart again with COCA. In terms of the time frame that you're asking, it's difficult for me to say. We have a few folks that I'm aware of who had lost takeaway capacity in those circumstances, and I think it would take several years often to get a new pipeline, and I can't speak to the economics of that. I think that's something that should be vetted through a variance as proposed in the existing rules. In terms of folks who have takeaway capacity when they first start, to Katie's point, it just really hasn't been a huge issue for us to really dig into a whole lot or look at, because we do have the majority of operators in Colorado who do that immediately, and it's just such a common practice. So on that score, I think that's all I could probably say about it. Your second question, I think, was around timing restrictions. We do have a voluntary program that many of our members participate in during ozone season. It doesn't necessarily apply to venting and flaring. However, there are a variety of practices that our operators employ throughout those timing restrictions, high ozone seasons, and really lower emissions through a variety of practices. Some of them are carpool programs, obviously not in COVID days, but carpool programs, P&A of wells, voluntary shut-ins. There's a number of practices. And so yes, that is very common, and that is something that we absolutely actively engage in.
If I could just add, this is Jennifer Beaver for Great Western. I think that I do want to make a point though about voluntary versus sort of mandatory, because there's limited exceptions to when you can flare now, right? So there's certain or venting or flaring. There's certain instances, for maintenance or for upset conditions, et cetera. The majority of the things, or a lot of the things that are well liquids unloading that are on that list of exceptions, while there may be some instances where, to Christy's point, you can voluntarily not do them, some of them you may have to do, or else you could cause, frankly, more emissions or create problems with your system. And so the concern I would have is just because the universe is already pretty limited, you want to make sure that you're not disincentivizing or telling people they can't undertake maintenance or things that they need to undertake for either continued operation or to ensure that the systems are operating properly. Certainly, I think, to Christy's point, operators do try to do that, and that's really important to them in the summer ozone months, but sort of too much mandates on that could really hinder some of the very reasons you have the exceptions in the first place, I think.
Thank you very much. That's all I have for my line of questions, so appreciate it.
Thank you, Commissioner Nanjapa. Commissioner Messner.
Thank you, Mr. Chair. I just did have one quick follow-up to one of Commissioner Nanjapa's questions. And so, I'm hearing from industry that the number of wells statewide that do not have gas capture, and so therefore utilize flaring, is 0.25 of 1% or something like that. And there are certain regions around the state, whether that's Jackson County, whether that's Fremont County, whether that's, you know, some other areas that don't have gas capture infrastructure. And I think it's over 80% of the wells in Jackson County don't have gas capture infrastructure. These rules will apply to them. The straw dog rules clearly indicated, you know, that came out almost a year ago that this would apply to them. And so I think what I heard Ms. Woodward say was they're going to need two, maybe 3 years even in order to be able to get this infrastructure in place in some areas. If it's not there, you know, we're a year now since the straw dog rules have been daylighted. The rules as drafted do create an additional 12-month window starting in January to be able to continue operations until that gas capture infrastructure gets in place. I think what Commissioner Nanjapa was asking was, can this happen for these operators that I assume are members of COGA or API? And is this a reasonable time frame? And if it is a reasonable time frame, is that time frame 6 months, 12 months? What's that time frame that needs to be in the rules?
Christy Woodward again with COGA, and I think those folks are not necessarily members of COGA, and so I do not want to speak on their behalf. All I can say is based on our membership and the conversations I've had, and my understanding is COGA would support the draft rules as proposed. Whether or not, you know, those people can do that or what their business status is, I'm not comfortable commenting on and would refrain from doing so.
Great. Yeah, thank you. And Commissioner Messner, thank you for asking that question. I was interested in the response as well. And we understand if that's not necessarily a question. Mr. Martin, did you want to answer or not on behalf of API? You're muted. There we go.
Chair Robbins, my answer is the same as Ms. Woodward's answer. These operators are not members of API, and API supports the provisions that are the subject of this conversation.
Okay, fair enough. Other questions for, Mr. Colglazer.
Chris Colglazer again. If I could add just a brief note, I think this may be site specific, right? It's difficult to set a single number that would work everywhere. You know, every facility has different geography, different access to easements. The land around it may be privately owned and developed. It may be national wilderness area, something like that. And so I think that does emphasize the need for discretion on the part of staff, or at least through the variance process, that some of these may be case-by-case decisions.
All right. With that question having been asked and answered 3 times, do we have other questions for the panel? Commissioner Gonzalez, and then Commissioner Putnam.
Thank you, Mr. Chair. Yeah, I've got a couple questions. I want to go back to some of the testimony on the, I guess, the gas capture plan and the coordination with APCD. You know, there's 3 elements of the gas capture plan that were cited as areas of concern, or at least areas that could benefit from some more guidance. I'm going to hit those kind of in turn. I'm going to start with number 6 about the BMPs maybe not being known at the time the 2A is submitted. I'm curious why those BMPs wouldn't be known, you know, for gas capture when you're, you know, typically operating in an area that you likely have some understanding of. I'm just curious why that'd be so much of a challenge to do during the OGDP phase.
Thank you for that question. I can answer that. I think during at the time of the 2A, we read that to be pretty broadly, you know, practices. Sorry, let me just pull up my notes here. Pretty broad best management practices to, you know, reduce emissions. And so I think it's just knowledge of what equipment you would have on location, how you would operate that equipment at the time of the 2A. And so I think, you know, the actual selection of specific equipment is really pertinent to those BMPs and writing those BMPs.
And that was Catherine Gillen from Great Western, for the record.
And Ms. Gillen, you know, how much, just kind of educate me on how much equipment changes from in terms of not necessarily the amount of equipment on site. I know that that's tied to various production estimates. It's tied to, you know, obviously the size of the pad, whether you're connected to, you know, straight into pipeline, all those good things. I'm curious as to why you may, I don't know, I'm just curious as to how much that differs across the state and across the basin.
Well, I don't know if I can speak for across the state or across the basin, but I can speak at least for Great Western. I think that in some cases, you know, we might, you know, reduce the amount of equipment on location. We might, you know, choose to drill fewer wells. So the actual number, you know, of separators, numbers of tanks at the time you actually drill, or the phase that you drill, would impact, you know, the selection of the equipment and construction of that equipment at the time.
I'm still, go ahead.
Yeah, this is Jennifer Beaver for Great Western. I think on number 6, which is about operational practices for minimizing venting during active and planned maintenance, right? So there's a lot of different pieces of equipment that active and planned maintenance can come from. And there's also differences in sort of technological advances, as I understand it. And Katie, correct me if I'm wrong. So that ultimately, you know, you will know better as you get closer to operation how you would plan to reduce or use best management practices when you're in those planned maintenance and active and planned maintenance timeframes. So I think it's, you know, somewhat the question, and then that information is going to be required when you get a permit from the Air Pollution Control Division, which you'll get, you know, much closer in time to actually drilling the facility, constructing it, and operating it, so that you'll have that information at a later date, and that information will be incorporated into a plan, an operating plan that's part of a permit.
Yeah, and to Jen's point there, you know, part of that permit will be, you know, quantifying those emissions, and depending on how we quantify those emissions, you know, some of those maintenance emissions may be controlled instead of vented. And so under that new GP11 permit, you know, depending on how, you know, we calculate those emissions, we might choose to control them instead.
Okay, and so do I understand it correctly that it's kind of a timing issue, that you want to go through the APCD process first, then you want to use that, leverage that into the gas capture plan?
Yeah, and we really just don't want those two things to contradict one another, and so it'd be difficult to have the information at the time of the 2A, and so we feel like it's appropriate, since it will be, you know, completed with the GP11 when there's sufficient information to make sure that those BMPs are accurate.
And so just for clarification, so the contradiction is not necessarily in rules or regulations between APCD and the COGCC for the gas capture plan. It's in the actual substance of that gas capture plan and what may go through an ACPD analyses in between the time you have a 2A and the time you start drilling the well.
For that section, correct. Yep.
And would the contradictions arise out of APCD imposing different or potentially additional requirements on you know, on what's being utilized versus what you had already put in your gas capture plan?
I don't know if I could speak to that one without really knowing exactly what those BMPs would be for Section 6. But I do think that in Section 8, that raises some concern for sure. And I think maybe Jen could probably add more color to Section 8 and what that contradiction might be. Chris also mentioned some of those contradictions in his testimony.
Yeah, and this is Chris Colglazer, if I could weigh in. I think it's not contradiction, I guess that's a decent word to use to describe it, but it's also about changed circumstances. So this gas capture plan will be submitted at the time of the 2A, and the well's going to produce for 30 or 40 years. And so even if you have pretty good information about the reservoir at the time of your 2A, you're modeling what your liquids and gas production will be decades down the road. You're trying to predict what your best practices will be to minimize venting during active and planned maintenance. We just think it makes much more sense to follow the rules that are in place at the time instead of going back decades potentially to look at something you said previously on a projection and use that to dictate what you do. So we think it's reasonable for planning, but it shouldn't overtake or override the rules that are in effect at the time the issues come up.
Can I follow up on that one briefly, Commissioner Gonzalez?
Please.
So I'm trying to square this with the new requirements to have emissions estimates in the CIDR database, as well as the cumulative impact plans and other pieces that are going to require consideration of BMPs at the 2A stage. And knowing that, yes, there's some potential things will evolve between getting the original permit and when you're actually there. Can a lot of that be handled through some sort of true up? I mean, that happens in planning processes and land use processes and other siting processes. I'm just struggling to see why you would kick that down the road if the commission needs the best understanding up front of what the impacts would be and what the plan is to address them.
I appreciate that clarification, Commissioner Putnam. Yeah, that kind of goes to kind of what I'm listening, what I'm trying to really drill down to is this an inconvenience for future reconciliation, or is this something that's not workable for planning purposes?
Go ahead, Katie.
I think that we really wanted to ensure that, the coordination of the development of guidance, particularly for separator sizing, was done with consideration of the existing storage tank work group guidance document that the division developed, just to ensure that, all of the work that we did there to ensure that storage tanks, for example, are adequately sized and are minimizing emissions. So I think our main point was to ensure that there's coordination in the development of that guidance, such that those don't contradict or cause any any contradiction, I suppose. Sorry.
Yeah, and this is Jennifer Beaver again. I guess I would just say that, we didn't propose to delete the language. We just proposed adding language to the statement of basis and purpose to effectuate kind of what Katie mentioned, to make sure that that discussion is ongoing, that it's coordinated. Katie mentioned, storage tank work group. That was several years in the making. It won an EPA award. There's a lot of good work that has been done by the Air Pollution Control Division. And I think making sure those are getting married up, and that, while on the face providing information may not be kind of inconsistent, if you will, how it's used, if it remains stagnant, how it evolves, how technologies change, kind of how best management practices change, just making sure that all of that is sort of coordinated, because those are efforts that are ongoing at the Air Pollution Control Division, I think was the real intention, and to make sure that as this gets implemented, it's really taking advantage of all that good work, if you will.
Thank you for that clarification. Mr. Chair, I want to, this kind of piggybacks on that same section and moves a little bit further into just in general liquids unloading and the notice thereof, that pre-notice. And so I'm curious as to how difficult it is to predict the frequency and the potential reduction of frequency on liquid unloading under the gas capture plan, because that was another concern for at least consultation. If it's just about consultation with ACPD, then perhaps we don't need to dig too deep into that specific question. But it kind of plays into to my question about the importance of pre-notice for the liquids unloading, and some more details around the challenges associated with that, with knowing when that's going to occur, and the, I guess, the risks or trade-off of risks when you consider the notice of the liquids unloading, and then compare that or trade off with the potential for damage to the wellbore and future issues that are emissions related, emissions producing.
Would like to tackle that?
I believe David Stewart is prepared to answer that.
Yeah, I'll weigh in on that question. You know, I asked that same question this morning in my operations group, so thank you for the question. Well liquids unloading is basically impossible to predict. It happens very quickly, many times. Sometimes it can build up over time, and you can predict it 12 hours in advance or so, but most of the time it's noticed by the lease operator on the location, and which requires an immediate action by that lease operator in order to prevent that well from basically settling into the point where you can't unload it, so that liquids will continue to build. And so that's our concern with the 48-hour notice, is that if we're required to notice that 48 hours in advance, that liquid will continue to build up to the point where the well will not unload. And if the well will not unload, at that point, then it requires a much more extensive operation to get production back online. And I'd be glad to describe the swabbing in more detail if you want more detail about that, but that's basically why it creates an emissions increase.
Yeah, if you could tell us about, I mean, I understand what swabbing is. I don't know if all of my commissioners do, but if they do, they can just go ahead and nod and we can skip on. But if not, perhaps it'd be a benefit if you could describe that swabbing procedure and what that looks like, and why that specifically could increase emissions as we evaluate kind of the weighing it against this pre-notice and putting on hold for that 48 hours.
Sure. Well, first I'll describe well liquids unloading. Basically, that's the process by which the operator opens the valve so the well can unload to the separator and not go into tanks. And then it will create an emissions event related to when the gas reaches the surface after the liquids unload. It can create an event where it can push a little excess gas into the separator and then into the tanks. Now, when you have to swab the well, it's a completely different story. You're bringing in a workover rig, which is about 35 feet tall, heavy piece of equipment. You're putting that on the well, so you're not only bringing truck traffic emissions in to bring that equipment in, but then the rig itself runs off diesel fuel. So you have a diesel emission source. You have a visual impact to the communities in which you're operating in, which is much greater than a simple liquids unload. And then you put a tubing down the well with the workover rig down to the place where it interfaces with the water that's built up in that wellbore. And then you drop that cup and that tubing further down into the well, 500 to 1,000 feet deep. And then you swab it, which means the cup goes against the edge of the tubing in the wellbore and pulls up that liquid to the surface. That liquid then goes into a surge tank. The surge tank is typically not controlled, and you do have some flash from those liquids. Usually it's produced water primarily, but it can be some oil mixed in there as well. And then you also bring up a little bit of gas, and you have to do that over and over and over until that liquid is out of the wellbore and the gas and oil can then flow freely again. Sometimes it takes 2 attempts, sometimes it may take 10. It just depends on the situation and how much liquid's built up. So by swabbing the well, you're creating a much, much greater, not only emissions impact, but impact to this, community around you, if you happen to be near homes, that kind of thing. So and I also don't think the 48-hour notice really provides the agency with any value. I just think for increasing emissions, it just doesn't make sense to me. And I'm open for suggestions and thoughts if the commission thinks they need that information ahead of time, but it is reported afterwards to the Air Pollution Control Division. And we could, report it to COGCC at the same time as well, or we could just marry those databases together because it is a requirement under Reg 7. Hope that answers your question.
One follow-up, and then I see Commissioner Putnam has his hand up, so I'll let him chime in after that. It just, in your professional experience, I'm not going to ask you to give a blanket statement, but in your professional experience, how often does a 48-hour delay in unloading result in the need for a workover?
I asked that question this morning to my ops team, and they said about 70 to 80% of the time.
And how often are the liquids unloading events occurring?
That's highly variable depending on the well. So the newer wells, it occurs much less frequently because you often have higher pressure downhole, and it's not required. But the wells that have declined to the point where liquids can block that pressure from the deeper well bore, it's much more frequent. I don't have the data in front of me to tell you actual frequency, but we could definitely pull that. We've recorded that and have records of all that for the previous years with our CDPHE data.
Okay, Commissioner Putnam.
Thank you, Mr. Chair, and thank you, Mr. Stewart. And maybe to get at the question of what the value of some of the prior notice would be, we're certainly seeing this as one of those non-continuous events, but infrequent events that nonetheless often have large emissions, and I think want to better understand it. And so sometimes if you have prior notice, you can get teams there to better monitor, observe, use flare cameras, whatever, just so we can better understand some of these events, recognizing some of the concerns that you identified about 48 hours. Is there some alternative that might be workable from an operational perspective, such as, as much notice as practicable or some standard like that, that may not be 48 hours, but presumably it will take a little bit of time to actually do the work to get it. And maybe that won't be enough for either COGCC or APCD to respond all the time, but maybe some of the times we can learn from it. And then in addition, just one last question on this point, are there other ways to get at understanding this problem, knowing one of them may be the continuous monitoring that Crestone Peak has right now, which could provide useful information. So I'll stop there. I think I've loaded you with enough questions.
Well, thanks, John, for those questions. Again, this is David Stewart responding. So I think there could be a compromise there as soon as possible. It's definitely an option. I think we could live with that as long as it was like an email notification or something pretty quick. A Form 42 could be pretty quick if we could email it over. But I would also offer that if this is an effort to gain more information about well liquids unloading and the emissions around that, I know that Crestone would, and I can't speak for the rest of industry, but I think many folks in industry would be very willing to work with both CDPHE and COGCC in understanding these events and coming up with a list of possibly ones that we could predict or we could see coming, and maybe have a task force put together that could mobilize very quickly that could come take a look at these events. As far as our continuous monitoring goes, we absolutely have seen well liquids unloading events occur at the sites where we have continuous monitoring. They do show up on our monitors. And so we could share some of that data as well. Although I would caution you that the canary is really meant to trigger an investigation, a deeper dive into what is causing the issue, not necessarily quantifying the emission rates from a particular event like that.
Thank you for that answer. I think Commissioner Putnam is done with his questions.
Actually,
oh, go ahead, Commissioner Putnam.
I had some questions for Mr. Colglazer, but we'll wait to see if other commissioners have other questions on this well unloading issue, or for Mr. Stewart.
Any other commissioners on this issue? I think you're free, Mr. Commissioner Putnam to move to a new topic.
Thank you, Mr. Chair, and thank you, Mr. Colglazer, for your testimony and comments today. Had a few questions for you. I think the first relates to the discussion that you had about the need for more guidance related to the kind of scope of some of the exceptions on venting and flaring, and you had the kind of simplified site diagram out for that. And kind of initial question, given that some of those really do get into jurisdictional questions, why guidance and not change in rule language, either in this rulemaking or in a future rule, just to make those more solid?
Mr. Cole.
Yeah, thank you, Commissioner Putnam. I think that guidance is a good step for now. I don't know that I have a position or my client has a position on a future rulemaking to look at these definitions again. I would say I think this definition is a tough one. We certainly want to have good delineation of the roles of the two agencies without limiting COGCC's statutory authority, but we think it is good policy for the agencies to coordinate with each other in terms of who is regulating what. But it is a tricky area because the nature of the emissions can change from site to site, or even at the same site, the nature of the emissions can change over time. And so our approach here, candidly, was to try to work with what staff had proposed to have a venting and flaring rule that addresses natural gas that should or could be sent to the sales line, and just try to work to define that through guidance.
Commissioner Putnam.
Thank you, Mr. Colglazer. A different issue, I think following up, you had made some comments and then I think had some back and forth with other commissioners about some of the comments and testimony of Dr. McCabe this morning and Mr. Freeman. One of the questions that they raised or concerns that they raised is whether the definition exempting a gas that may go through tanks will create an incentive essentially to waste gas by routing it through tanks. And I think your comment on that was that the Air Pollution Control Division will be looking at the emissions associated with that, which I certainly agree with, but I'm not sure that the division staff is going to be looking at it from the perspective of waste. So wanted to get your perspective on whether we need to make some adjustments to those definitions to address the concerns given this commission's statutory direction to avoid waste.
Mr. Colglazer.
Yeah, thank you again, Commissioner Putnam. It's an excellent question. I think that the commission already has authority on the books to regulate waste, and certainly the statute and the rules define waste as excessive or unreasonable escape or loss or destruction of natural gas. And I think that standard will remain in place after this rulemaking still. And so if you do have a situation, which I think would be very unusual, where, you know, as Mr. McCabe was sort of speculating that an operator might just omit a separator and route everything to gas for reasons I don't understand. You know, I think if there is a volume of gas that is being sent through the tank instead of sent to sales, that the commission already has the authority to evaluate whether that constitutes waste under the existing rules, whether that's excessive or unreasonable. So I'm not an expert on waste, so I think I'll stop there to say that, you know, there is a rule in place that lets you evaluate case by case whether something is excessive or unreasonable. I think that describing emissions as waste when you get farther downstream of the separator is much more tricky and complicated. Historically, COGCC has allowed CDPHE to regulate those emissions and have not considered emissions from production equipment to be waste. Not to say it never could be, but I think that it does get more complicated when you try to define what is excessive or unreasonable from production equipment as opposed to emissions from the separator or from the wellhead. And I think there was another part of your question too about the scenario that Mr. McCabe put forward and how those emissions are regulated by the Air Division. You know, again, I think this is a very unlikely scenario that he posited for us. And I believe I heard him admit that he's not aware of any situation where this is happening, where an operator just goes out and deliberately builds a site without a separator when it should have one. But there have been instances where facilities were operating without a separator. Maybe they lost takeaway capacity over time, and CDPHE and the EPA brought enforcement cases against them. So there are rules in effect on the books, and the agencies have shown a willingness to enforce those rules to make sure that companies are accurately or properly designing and operating their tanks to minimize emissions. And so if an operator were to take high pressure gas from a separator and send it to a tank, that very likely would cause venting as CDPHE defines it. It certainly could be a violation of the design requirements, and the agencies have enforced against that in the past. So I don't think it's a realistic concern that you really need to think about writing another rule to outlaw that again.
Commissioner Putnam?
Great. Thank you. And we can follow up on some of those when we get to deliberation. I just had one more question or line of questions, and that related to, you referenced Director Gary Kaufman's comments that he made to the Air Commission last week about the scientific aviation overflights. And I think you had noted that he did flag that from one flight, it did show a lower methane flux, I think, than previous overflights. I just wanted to make sure we captured the full context. Didn't Mr. Kaufman also note that it was just one flight out of many that we have planned, and warning the commission not to draw too many conclusions from just one flight?
Yes, and this is Chris Colglazer again. Yes, certainly agree with that. And I tried not to overstate what he said. I believe I noted that it was preliminary data showing that methane emissions have fallen faster than anticipated. I would say that it's not the only source of data. Certainly more data will come through the Air Quality Enterprise and other sources that work will be done. I believe that the division collects VOC data from the Platteville monitoring site that has also showed a decrease in VOCs related to oil and gas. So there are some good pieces of data in addition to the inventory that's on the books that have shown declining emissions. And frankly, you would expect that given the significant changes this industry has made over the years to cut emissions.
Thank you, Mr. Colglazer.
All right, other questions for this panel? All right, well, panel, we want to thank you for your presentations and for bearing with us. It's been 2.5 hours, but that's really good. We've been able to ferret out a lot of good information from you, and we appreciate your written product as well. With that, I believe we will Zoom this panel away and take a afternoon break of about 15 minutes. It's 3:48, maybe come back at 4 o'clock, 13 minutes. And then we will probably go back at that point to Conservation Colorado and the affiliated groups with those guys. And hopefully they are up and running now. So we'll see you in about 12 minutes, guys. Hey, welcome back, everybody. This is the Colorado Oil and Gas Conservation Commission hearing on the 900 series. We're in the midst of stakeholder input. We just finished the industry group. Want to have a quick discussion with commissioners about today and the rest of our rulemaking. But I'm gonna wait until all of our commissioners show back up. Oh, there they are. They are lurking around the corner. Just wanted to get a sense of today, and the rest of today is 4 o'clock now. Our next participant will be Conservation Colorado and their affiliated groups for a 15-minute presentation. We then have scheduled Environmental Defense Fund with allied local governments and Aurora for a 15-minute presentation. I am somewhat of the opinion that perhaps we take those two up. That's 15 minutes each, and I anticipate there would probably be some questions and answers from commissioners on their presentations, and then potentially call it a day. That would get us to right about 5 o'clock and would honor the fact that everyone has evenings that should be on their own. We are scheduled tomorrow and Thursday. The way that this is set up, I think that tomorrow and Thursday we would still be able to sort of get through the rest of stakeholder presentation and then commissioner deliberation. Right now we're not teed up for Friday, and I still think we could meet that, but that's just one commissioner's thoughts and ramblings. And I see that Director Murphy has showed up, so I would love to get input from the director as well on calendar and next steps.
Thanks, Chair. The only piece I wanted to add is that we have arranged for CPWC folks from the Water Quality Control Division within CDPHE and Evergreen Natural Resources to be available tomorrow at approximately 11:45. And so I think that however late this commission wants to work this evening or not, as long as we can break around 11:45 to kind of work through the questions or concerns that the commissioners had around public comments we received yesterday with those folks, so we can get them on and then let them go on about their day. I know that the state folks have at least rearranged schedules. So as long as with that caveat, I think that what the chair has laid out makes fine sense to me. I'm here as long as you all need me.
Yeah, and I'm here solo, so I can go as late as need be. I'm just trying to be cognizant of other family obligations, and I think we certainly could make that break tomorrow to accommodate that, and then go back to additional public comment. But do commissioners have other thoughts?
Mr. Chair, I'm fine with going a little bit later this evening if that works for other commissioners, if we need to, or alternately just going with what you proposed and breaking at 11:45 for the presentation.
What are our thoughts? Commissioner Messner?
Thank you, Mr. Chair. I'm easy as well. I have no life, so I'm happy to go as late as we need to tonight if that gets us further ahead, so that we don't run into any kind of time crunches. So, I mean, it's good for me to go a little longer tonight if that works well, but if I'm easy, so whatever works best.
Commissioner Poe.
I'm also very flexible, happy to do either. I might have to jump off if we go beyond about 5:30 just to go home. My husband will come and pick me up, but I could jump on the phone. So again, very flexible.
I'm flexible.
McGowan, you're turning into the swing vote here.
I have a life, but I'm also flexible. I can go later tonight, so.
All right, Director Murphy, tell us what you want us to do.
How about we go till 5:30? We'll try to not lose quite as much ground. Feels like a compromise. 5:30 isn't an unreasonably late hour.
Perfect. All right, 5:30 it is. Hearings Manager Thomas, who is subbing in for Hearings Manager Larson, and we really appreciate that. If you could bring on board Matt Sura and his witnesses, we will get started. Good afternoon, Mr. Sura. And it looks like we have your witness. Are you ready to roll?
Yeah, I am. I'm going to just share my screen here quickly. I assume you can see that?
Yes, we can.
Wonderful. Good afternoon, Commissioners. Matt Sura, representing Conservation Colorado and allied organizations. First, I'd like to thank the staff for the excellent work that they did on the 900 series. We don't have the time to comment on all the changes we support, but wanted to express our appreciation for the staff's expertise and the commitment that they've demonstrated to the objectives of Senate Bill 181. We're recommending small changes that would improve these three areas. Primarily, we want to support the limits proposed on flaring and the language EDF is proposing to strengthen those limits. We're also asking you to support modest changes that will encourage increased recycling and reuse of produced water. And finally, we ask you to consider a small change to reduce the number of new waste pits in Colorado. And now I will turn it over to our witness, Barbara Vasquez, a resident of Jackson County.
Good afternoon, commissioners. Can you hear me all right?
We can.
Thank you. I appreciate the opportunity to speak with you this afternoon. I'm Barbara Vasquez, a retired research biochemist with a PhD in chemistry, as well as experience as an engineer and currently a resident of Jackson County, having moved there in 2005. I focused my volunteer work on environment, public lands, wildlife, and human health. I've served as the environmental representative to the North Platte Basin Roundtable since '06. I serve currently as their representative to the Interbasin Compact Committee, serve on the BLM Northwest Colorado RAC for 7 years, and am currently Transportation Commissioner representing Northwest Colorado. I want to thank the staff in particular for a very informative presentation yesterday morning, and thank them for all their hard work to get us where we are today. And I was particularly encouraged with the effort described to strengthen the communication and coordination with COGCC and CDPHE. Jackson County, known as North Park, is a high mountain basin covering about 1,600 square miles, 65% of which is public land. Jackson County and Sandridge Energy were mentioned a few times yesterday morning in the staff presentation as an example for flaring. I'll be speaking as a resident of North Park, an observer of this development, as a member of the public for the 14 years since the first horizontal well was drilled, and will be using publicly available information in my remaining comments. For those of you not familiar with North Park, please let me introduce you to this part of the state, often unfamiliar to many. North Park is the headwaters of the North Platte River. The mountains that form the perimeter of the basin host multiple wilderness areas, and the agricultural economy is based on irrigated grass, hay, and cattle production. North Park the North Platte River system supports abundant wildlife, including big game and wild trout. The wildlife plus the large tracts of public land enable an evergreen economy based on outdoor recreation. Important big game habitat migration corridors in North Park is shown on the map to the right and must be protected to sustain that economy, creating the need for restrictions and posing some conflicts with oil and gas development over the years. North Park has the second highest waterfowl production in Colorado and hosts the Arapaho National Wildlife Refuge, which sits right in the middle of the basin. It's currently surrounded on 3 sides by oil and gas development. It provides habitat not only for waterfowl, but also aquatic mammals, amphibians, migratory birds, and big game. Priority habitat for the greater sage-grouse blankets the floor of North Park, creating the need for additional restrictions on development to preserve this isolated population. And if it sounds like I'm giving introductory comments for 1200 series, it's important to understand the landscape in which this development is occurring. Oil development is not new to North Park. The McCullum Field to the northeast of the basin is dotted with older vertical shallow wells, no fracking or flaring, first drilled in the early 20s. Each of these wells have a small footprint, a single pump jack, a single tank. The horizontally drilled wells, which are fracked and flared, are grouped in the southwest quadrant of North Park with much greater footprint per well. You've all seen these types of installations with multi-story pump jacks, large tank farms, and flare chimneys. Sandridge Energy is the current owner of the shale assets and operations in North Park, and this map is from their May 2018 investor presentation. It demonstrates the extent of their lease holdings. Note that many of these leases are on private surface. The status at the end of August 2020 is listed below, with 100% of the co-produced natural gas from their 64 listed wells disposed of by flaring. The total gas flared through the end of August 2020, taken from your database, the COGCC database, was almost 800,000 MCF. A summary of the gas produced and flared is shown in this table in multiple counties in the state. You'll notice Jackson County is second from the bottom for the volume of gas produced, but is second only to Weld County in volume of gas flared, in spite of having only 6% as many wells as Weld County. As you can see, Sandridge is flaring 100% of their produced gas. A comment was made by industry earlier this afternoon that in 2018, only 0.25% of all gas produced in the state was flared. But if we focus on the gas co-produced from oil wells, where it is often viewed as a waste, that percentage is much higher. Nobody would drill a gas well without takeaway capacity, but they often have drilled oil wells without that infrastructure, as in North Park. You've heard staff presentations as well as comments from members of the public about the reasons to stop flaring except in emergency or very short-term upset conditions. Emitted along with uncombusted methane for an enclosed combustor operating at 95% efficiency. The emitted VOCs and HAPs impact public health and welfare has been well described in previous comments to this commission. To my knowledge, there's no air quality monitoring being done in North Park, so those of us who live in the park don't really know what we're breathing. In addition, the incompletely combusted methane plus the produced NOx and CO2 accelerate climate change. As you can see and hear in this video that I captured in North Park in the fall of 2019, these flares appear to be operating in an overpressurized condition. The efficiency of combustion is likely reduced under this condition, resulting in greater emissions of pollutants. I'm encouraged to hear that CDPHE and the CEO are working to set targets in conjunction with the greenhouse roadmap for various sectors and look forward to a preview of the oil and gas targets so we can help ensure that COGCC rulemaking supports those goals. As you heard from Dr. McCabe, there are multiple alternatives to flaring. The most obvious is connecting to a pipeline to get that product to market, something that Sandridge was promoting to investors in 2017, as you can see from this slide. In November 2018, they announced a gas to liquids pilot program with Advantage Midstream, and you may be interested in the technology that's described here. They have movable, mobile, scalable modules that convert gas to diesel and naphtha with no residual gas, eliminating any need to compress or flare natural residual lean gas. This pilot was run using gas produced from 10 wells by Sandridge in conjunction with Advantage Midstream for 8 months in 2019, but then was stopped. Gas production from September 2019 to present is still being 100% flared. In summary, for all the reasons that have been reinforced by the staff presentation yesterday, commissioners' comments and questions, as well as public comments, we're asking COGCC to put rules in place for both new and existing wells that will eliminate flaring for all wells and operators, except in unusual upset or emergency conditions. The contribution to climate change alone should be sufficient motivation. And it's personal for me. I was evacuated in front of the Mullen fire earlier this month. It didn't make much news in Colorado since it originated in Wyoming, but it currently is standing at over 180,000 acres, about the size of the East Troublesome fire. It made 2 spectacular wild wind-blown runs, one 8 miles in a day to the east, and the second 7 miles in a day to the south, which drove me from home. I look forward to this commission eliminating routine flaring for new and existing wells, except in upset and emergency conditions during your tenure.
We support the citizen group red lines to close the potential loophole that could allow venting through tanks. We did not hear the industry object to the reasonable requirement that separation equipment must be properly sized to prevent waste of the resource for the venting definition, and that same language makes sense to prevent excessive flaring. We also support EDS red lines that will be discussed later this afternoon or tomorrow morning, but want to emphasize the language on the screen. We believe the rules would be greatly improved if it was stated upfront that venting and flaring is prohibited. Once routine flaring at existing locations is stopped, you will still be receiving requests from operators to flare if there's a pipeline disruption. For example, at the Triple Creek site in Greeley, Colorado, the operator lost gas line capacity just as 22 new wells were coming online, resulting in flaring for months and also resulting in health complaints to both the Colorado Gas Conservation Commission and CDPHE. In this case, operators will argue that they needed to flare. It should be clarified how a Triple Creek situation will be handled, and there is good cause for parties' confusion on this issue. 903D states that an upset condition cannot last beyond 24 hours, but then requires reporting on a Form 4 for any flaring lasting longer than 24 hours. That's in 903D2. The statement of basis and purpose states that the operator could submit a Form 4 sundry notice under 301C if there are unforeseen circumstances and they're not able to connect to a pipeline or meet the requirements of a gas capture plan. Similarly, 903E3 states that a director may require a shut-in if an operator is flaring, which I read to give the director discretion to allow that flaring. We encourage you to pass clear regulations that would require an operator that loses his pipeline capacity or is not in compliance with a gas capture plan to shut in until pipeline capacity is restored rather than being allowed to flare. If exceptions need to be made, they should be made through a Rule 502 variance process rather than allowing a Form 4 or a request for relief through a 503G10. Now we're going to move to reuse and recycling of produced water. In this report released in 2008, API estimated that hydraulic fracturing in Colorado uses 6.5 billion gallons of water a year. This water generally disappears downhole or returns as flowback and is disposed of in a Class 2 injection well.
Even before the climate crisis became so obvious to all of us, our state was preparing a drought plan for a potential call on the Colorado River. Work is underway to update the Colorado Water Plan with a solid focus on climate change. From a North Park perspective, the amazing biodiversity of our basin, as highlighted on this slide, is possible because of water born of snowfalls in the mountains. That's true across the state. So with climate change, we will have much less water. We're asking the COGCC to reduce the water footprint of the oil and gas development in Colorado. Currently, fresh water is used to extinction for fracking, removing 6 to 8 million gallons of fresh water per well, depending on the depth and length of the horizontal bores from the hydrological cycle. Gone forever. Produced water is treated by oil and gas industry like a waste, and we're talking about waste rules here rather than looking at it as a resource. It's been demonstrated in other areas of the country that it's possible to recycle and reuse at least a percentage of the produced water for drilling and fracking. COGCC should seize this opportunity to establish a roadmap and rules to drive reuse and recycling of produced water by oil and gas operators in Colorado.
Pennsylvania offers a blueprint for Colorado because its regulations prioritize reusing flowback and produced water. Pennsylvania regulation requires the operator to submit a wastewater source reduction strategy that identifies ways to maximize the recycling and reuse of flowback and produced water. In 2017, 52% of flowback and produced water from Pennsylvania wells was reused at well pads for oil and gas operations. Our proposals mirror the change to Rule 903 that would simply require an evaluation of reuse and recycling operations. However, as has been seen in Pennsylvania, requiring this evaluation is an important step and can lead to a cultural change that will ultimately limit the amount of water that is currently used and wasted by the industry. Now we're going to move to elimination of pits. We agree that the industry needs to determine and report what pits are still operating. This is a map of Dacono, Fort Lupton, and Erie that shows pits that have been closed in dark green, still open in light green, and an unknown status are in white. Pits are not a best management practice. In fact, they are an outdated practice that in the statement of basis of purpose mentions are now rarely requested. New pits have no place on the Front Range in the Wattenberg Field and are only rarely needed. Pits are dangerous to wildlife and can damage water quality and air quality. While we would prefer the position of the community groups that would eliminate the use of most pits, we are offering the following alternative language. New pits would not be constructed that would have uncontrolled actual emissions greater than 2 tons per year. The Air Quality Control Commission requires tanks to control emissions down to 2 tons per year. That started in the ozone non-attainment area, but was soon expanded statewide. By allowing pits to pollute up to 5 tons per year, the Colorado and Gas Conservation Commission could be unintentionally encouraging the use of new pits. Finally, on the issue of netting, we believe that Senate Bill 181 requires you to use whatever language will result in fewer deaths to wildlife. It would appear to us that requiring netting, but allowing the CPW to grant waivers is the more protective language, but would defer to CPW on that issue. That concludes our comments. Thank you.
Thank you. Couldn't find my unmute button. Strange, given all the Zooming we're doing. Thank you for your presentation. At this time, I would turn to commissioners if there are any questions. Commissioner Bowe.
Thank you, Chair. This question is for Ms. Vasquez. I'm wondering, do you have a sense of why the pilot project for the gas liquids effort was ended by the company in North Park?
First of all, it was being run by Advantage Midstream in collaboration with Sandridge. I have no insight into the financial arrangement or the results of the experiment. You can see on the COGCC database that there were sales resulting from that experiment. I don't know whether it was profitable or not, so I'm not in a position to comment. However, related to comments that were made previously about the alternatives to flaring that Dr. McCabe listed, there were questions regarding profitability, and I would just comment that if we were pricing the social and environmental cost of venting and flaring appropriately, there would be a lot of room for operators to use some of these alternatives and still make their profit.
Thank you for that. Commissioner Bowe, did you have further follow-up?
No, that's it. Thank you.
Great. Other commissioners with questions? Commissioner Messner.
Thank you, Mr. Chair. And thank you, Ms. Vasquez, for that presentation. I found that to be very helpful, very informative. But Mr. Sura, I did have one question just to make sure that I understand around the recycling of water, the reuse, and the water plan. Your suggestion, your action item is to change the language in 905A to include that evaluate section, and that's it, right? That's the ask, or is there additional adjustments to the rules that you're seeking?
Thank you so much for the question, Commissioner Messner. We certainly had more extensive red lines that we proposed in our pre-hearing statement. And through my experience, extensive red lines at this point rarely get passed. And so we've pulled it back to something that is only simply requiring evaluation of opportunities for reuse and recycling, rather than requiring that as for all operations. Again, what we've seen in both Pennsylvania and Texas is that it's really a cultural shift that has occurred in those states where they, because they're required to do these evaluations, they are finding that they can be done, and ultimately it's more profitable than having to revert to disposal and the trucking that occurs with that.
No, I appreciate that, and I'm also a big advocate for the reutilization of produced water And so I appreciate the suggested language. So.
If I might jump in here just once, Mr.
Yes,
Sura, I'd like to comment. I have watched tankers drop their load of produced water illegally. I think if all we did was asked for a transparent reporting of water produced, water transported, the volume that was delivered at the destination and how it was disposed of, that transparency would help a lot.
Thank you. Other questions from commissioners for this panel? All right, I'm not seeing any. I want to thank Ms. Vasquez for her testimony. It was, I thought, very well done, and it's great to hear from someone that is living in that area and that has that level of understanding of the issues that we're addressing. So that was really helpful. So thank you very much for taking time to present to us and to hanging with us this afternoon. I know we kind of got to you guys later. But with that, we will excuse this panel.
Thank you.
And bring our next panel on board, which is EDF, the Allied Local Governments, Gunnison County, and the City of Aurora, I believe. You're looking to bring Ms. Pranos on?
Good afternoon, Commissioners. Elizabeth Pranos here on behalf of Environmental Defense Fund, the affiliated local government coalition, and the City of Aurora. Bear with me 1 minute while I attempt to share my screen. Interesting. Okay. Let's see. Are you all seeing my, oh, hang on. Nope. Let's see. Are you seeing a presentation now?
Yes, we are.
Okay, fantastic. Great. So with me today is Tom Alexander, a former oil and gas executive and current consultant with EDF. Tom will provide testimony at the close of my presentation. And the City of Aurora and the affiliated local government coalition supports the testimony that I'll be providing today on behalf of EDF. First, I want to thank staff and the Commission for all of the hard work, time, and thought that has gone into Rules 903 and 904. EDF worked closely with staff and other stakeholders, including industry parties, to strengthen Rule 903, and we commend staff on proposing a strong rule. Proposed 903 will go a long way towards reducing waste and minimizing pollution caused by venting and flaring. In particular, we support the ban on routine flaring during production contained in Rule 903 D1. We also support language in the Statement of Basis and Purpose that requests for a variance to flare or vent are disfavored. As Commissioner Messner mentioned this morning, Rule 903 bans venting and flaring during production, other than in very limited, explicitly enumerated instances. We agree with Commissioner Messner that operators face a high bar when seeking a variance and expect the Commission to grant variances to Rule 903 sparingly. We also support the language in the Statement of Basis and Purpose that authorizes the Director to approve, quote, at most, a one-time 12-month request to flare or vent from existing wells. We urge the Director to grant these administrative approvals sparingly and to limit the duration of any approved venting or flaring to the minimum amount of time necessary to allow operators to implement alternatives to flaring and venting. With a few modifications that I will review shortly, we believe Rule 903 represents one of the strongest rules in the nation with respect to addressing venting and flaring of natural gas that could be sent to sales. We suggest 5 revisions to Rule 903. The first is that we recommend the Commission add this provision that you see in red, which adds a new provision that explicitly sets forth the Commission's intent and requirements in Rule 903 with respect to minimizing waste. We believe adding this language is important to assure the public of the Commission's intent to prohibit waste and to require flaring rather than venting where capture is not feasible. Second, Rule 903 D1 contains the Commission's prohibition on venting or flaring during production, other than in specifically enumerated exceptions, including production tests. As Mr. Alexander will explain in his subsequent testimony, we suggest the time frame for flaring during production tests be reduced to 30 days with the opportunity for an operator to request permission to flare for an additional 30 days. Third, we suggest aligning certain of the information that operators are required to provide when they provide a Form 2A gas capture plan with information that operators need to provide when they submit a gas capture plan pursuant to a Form 4, or when operators provide a commitment to connect to a gathering line pursuant to Rule 903 E1A. So here you'll see the 4 types of information that we are suggesting operators be required to provide pursuant to a Form 4, or when they submit a commitment to connect to a gathering line. The first 3 of these are currently required by operators who submit a gas capture plan pursuant to 903 E1B. This information in the red is equally applicable to an operator of an existing well and to an operator who submits a commitment to connect with a Form 2A. We don't see any reason to exempt operators submitting a commitment to connect to a gathering line or seeking permission to flare from an existing well from the requirements to submit information on measures the operator will take to limit emissions during equipment maintenance activities, or steps the operator will take to minimize the frequency of manual liquids unloading events, or the anticipated liquids and gas production, and a description of how separation equipment will be sized to optimize gas capture. We also suggest new language that you'll see in the 4th bullet here, that we suggest this be added to both 903 E1A and B and 903 D3 to ensure that any flare and combustion device will be able to achieve the required 98% destruction removal efficiency that staff required per the rules. The next several slides provide our specific rule language for each of the provisions that I just went over, and this language we will send to you after my presentation. 4th, in Rule 903 E1A, currently the rule allows an operator to commit to providing a commitment to connecting to a gathering system by the commencement of production operations in lieu of providing a detailed gas capture plan. To increase accountability, we suggest that this commitment be signed by a responsible official. This ensures accountability by placing compliance responsibility on those in the best position to assure that the operator will fulfill its commitment to connect. AQCC Regulation 7 requires a responsible official certify a number of compliance reports, including the annual report that operators need to submit with their leak detection and repair requirements, their storage tank control and monitoring requirements for the non-attainment area, and also an annual report that demonstrates compliance with implementation of best management practices to reduce emissions from the transmission segment. And then lastly, as we noted above, we believe that clear rules that leave no room for interpretation are essential to good government and compliance. Thus, we recommend the addition of language in Rule 903 E3 that makes it clear that the director and the commission will not approve of a Form 2A that fails to demonstrate that the operator will capture, rather than vent or flare, natural gas during production. And that concludes my presentation. And next we have Tom Alexander, who hopefully has been added, who will speak to a few of the points that I just mentioned.
I'm here. Everybody can hear me okay?
Yes, we can hear you.
Good deal. Okay, well, I think it's almost good evening, commissioners. I appreciate the opportunity to testify on behalf of EDF. My name is Tom Alexander. I've been consulting to EDF for a little bit over 4 years, just after I retired from active duty, as I'll put it, in the oil and gas industry. I have 39 plus years in upstream E&P engineering operations, and the last 4 years of my working career, full-time working career, was as the Vice President of Health, Safety, and Environment for my company, Southwestern Energy. During my engineering time and operations time, I was recognized as an SME in unconventional resources with regard to completion and production engineering. We were the second major unconventional resource discovered and developed in the Fayetteville Shale. So I have over 30 years of E&P engineering and operational experience. Educationally, I earned a bachelor's degree from Wake Forest University, did postgraduate work at Duke, and then joined the Air Force. During that time, I went back to school and received a BS and an MS from South Dakota School of Mines and Engineering and Technology, rather, in mining engineering. Never did that, went straight into the oil and gas industry. I also completed all the coursework at Denver University for a master's in environmental management. My testimony today is limited to proposed Rule 903. And I am here to support everything that Ms. Perennis has already talked about. I've read and studied the proposed rule. I listened to its presentation yesterday, and in my opinion, it's a very reasonable and necessary approach to not only curb waste, but minimize pollution caused by excessive or routine venting and flaring. And I think it represents sound technical and operational reason. And I commend the staff in proposing to clearly limit and then prohibit routine flaring from existing and new wells. I'd like to make a few additional points, though, one of which has to do with Rule 903D1C, where a period not to exceed 60 days is provided to allow flaring during production evaluation or productivity tests. We propose that that be changed to 30 days. I recognize from the engineering and the technical or the economic perspective, one size does not fit all. That's certainly true. But with the tools available today to reservoir engineers, rate transient analysis, et cetera, we really believe, I really believe 30 days is almost always going to be sufficient time to gain a good understanding of a well's potential. And we would propose the 30 days, and then if the operator can provide ample evidence, good technical reasons why it should go beyond the 30 days, then they should do so, and that would be just fine. But I really do think that 60 days is excessive and is going to lead to additional waste and additional pollution that is probably not really necessary. I want to commend the staff for inserting in this rule a gas capture plant. I think it's a tremendous addition to it. As Ms. Perennis noticed or noted in her presentation, we also suggest aligning that the information that operators must submit when requesting approval to flare, administrative approval, that they be same for whether it's a new well or an old well. It really doesn't make any difference. And in particular, the three items that she pointed out concerning operational best practices, which I'll be glad to comment on if there are any questions with regard to that, to minimize venting during active and planned maintenance. The other two are that the operator would employ procedures and talk about those procedures to reduce the frequency of well liquid unloading events. And then finally, the anticipated volume of liquids and gas production is a description of how separation equipment would be sized to optimize gas capture. You know, another feature of that understanding the entire revenue stream, the entire production stream is so that staff and so that commission can adequately evaluate when the operator is justifying flaring or not. You know, the economics around this, so many times or frequently, the economics around midstream connection or downstream connection is based on gas production only. I think that the entire revenue stream should be considered in that case, as opposed to just the gas production. So in both cases, whether it's existing or new wells, that data should be made available. It will just make it a whole lot easier to evaluate the cost to connect to a gathering line, evaluate potentially how long an operator may need to connect, and as has been mentioned before, the evaluation of the other technologies to capture gas, There should be more included in that other than the gas stream alone. So that concludes my testimony and my support of what has already been said, and I'm available to answer any questions that you have. Thank you for your time.
Thank you both for your presentation and testimony. At this time, we will have an opportunity for commissioners with questions. Mr. Alexander, I just had one quick one. You floated in your testimony that 30 days is sufficient for exploration wells to, generally make determination, as opposed to the 60 that is in the draft that was from staff. Can you provide some further perspective that provides background as to why you believe 30 days generally would be sufficient?
Well, I'm just going to speak from our experience in the Fayetteville Shale. Now, so really the length of time here is primarily from a technical perspective based upon the permeability of the reservoir. These unconventional reservoirs with nanodarcy permeability, tight rock, versus something with, a millidarcy is a world of difference. But in the tight rock, and we ran into this obviously in the Fayetteville Shale, and we explored, we discovered, we drilled 4,000 plus wells. We never took that long to use rate transient analysis, and my gosh, this has been 10, 15 years ago, and or tight curving to get a very good idea of what that well's capability was. Also, I'm not going to want to be flaring production streams for the first 60 days in those kind of wells very much, because that's where you make your gravy. Now, if you've got primarily an oil well that has associated gas with it, I understand the perspective there is, well, I would really like to make the money in oil production and not worry so much about the 20 or 40 MCF a day. So I understand that scenario, but I just don't think that you need that much time generally. Let the operator justify why technically it should take longer. We never used 30 days. As a matter of fact, I think Arkansas limited it to 2 weeks. I may be wrong about that, but that's my recollection of it. I hope that helps.
No, thank you. That helps. I appreciate that further follow-up.
I mean, that's from a reservoir engineering perspective.
Okay. Other questions from commissioners? All right, I'm not seeing any. As you thanked staff, we also want to thank EDF and your client group, Ms. Paranos, for the work that you did and background in terms of helping guide this. And so thank you very much. And we appreciate the receipt of your slides with your 4 edits that you're looking for that have also been supported by a number of other of our stakeholders. So thank you for your leadership here. And we will zoom you away and bring in Kinder Morgan CO2 Company.
Good evening, can you hear me?
We can hear you and we can see you.
Let me share my screen. Okay, are we seeing a presentation?
Yes.
Good evening. My name is Ana Gutierrez with Hogan Levels, and I'm here on behalf of Kinder Morgan CO2 Company. Thank you, commissioners, staff, and Director Murphy for the opportunity to present testimony on the 900 series rules. I'm presenting today on a very focused issue with respect to Rule 915 and the 915.1 table. In particular, Kinder Morgan CO2 is requesting that the Commission adopt an additional footnote below the 915.1 table that codifies the Commission's 2008 guidance on how it implements the soil suitability for reclamation concentrations for pH, electrical conductivity, and sodium absorption ratio. Following the 2008 House Bill 07-1341 rulemaking, the Commission developed a guidance document that is now known as the 2008 Frequently Asked Questions. In this document, the Commission clarifies that the screening levels for pH, SAR, and EC concentration apply to, quote, soils that are within 3 feet of the ground surface because elevated levels in deeper soils should not adversely affect the successful reclamation of the site, which is the objective of these concentration levels. To put this in context, as noted in the guidance, the purpose of adhering to the Table 915.1 soil suitability concentrations is to allow for successful reclamation, meaning the soil must be restored to the agronomic properties to allow for vegetation growth. The Commission and staff previously determined that the table concentrations for pH, EC, and SAR apply only to that 3 feet below the surface because this does allow for successful reclamation. And this is also consistent with the current reclamation requirements in the 1000 series. Staff have not presented data that indicate that this determination has changed. And in fact, we don't think staff intends to move away from what has been longstanding guidance and effectively a de facto rule. So it's important that this substantive guidance, which is still applied as good guidance, be carried forward into the Rule 915 table, given that that is the stated goal of staff and the Commission to codify prior guidance. Specifically, staff notes in the draft statement of basis and purpose that prior to this current rulemaking, the Commission addressed soil suitability for reclamation through the prior Table 915, so 910, through guidance, and through a list of frequently asked questions, including that question number 32 that we discussed. The statement of basis and purpose goes on to state, quote, codifying these standards provides clearer regulatory expectations for operators and improves regulatory certainty. So consistent with the Commission's intent, we are asking that an important element of the prior guidance and practice that is specifically referenced in the statement of basis and purpose be adopted as a rule to ensure that the new rule affords regulatory certainty to all parties. We are proposing that an additional footnote shown on the screen here be added below the Table 915.1. Now, as staff and the commissioners consider this proposal, please recognize that this draft rule is not a bright line rule, because we recognize that there may be unique circumstances when it may be otherwise necessary to consider exceedances below the 3 feet. Rather, our proposal carries forward the clarification that has been implemented since 2008 that these concentration levels apply to the soil that are within the 3 feet of the ground surface, unless it is determined by the director that such concentrations in deeper soils would adversely affect the successful remediation of the site. That concludes my testimony, and I'm happy to take questions.
Thank you for that testimony and for your presentation. Do we have questions? Commissioner McGowan?
Thank you, Mr. Chair. Thanks for going into the wee hours with us. Are you worried that because it's not noted in the footnote that staff isn't going to use it as guidance anymore? I'll stop there. Is that what we're worried about?
Thank you, Commissioner McGowan, for the question. That's precisely what we are worried about, in part because this guidance document that operators have downloaded from COGCC's website is no longer available on COGCC's website. So without clear communication on whether this is going to be the continued intent behind the regulation, I think we would like that clarification.
Follow-up, Commissioner McGowan.
Thank you, Mr. Chair. I'm wondering if staff could let us know what their thoughts were about continuing to use the 2008 guidance, or if there's something else that they had in mind.
AAG Minor.
Thank you, Mr. Chair. I think I can give a preliminary answer, or Director Murphy can, and then perhaps depending on the detail of questions that the commissioners would like to ask, we can zoom in Dr. Arthur or Mr. Axelson. It was staff's intent not to codify that specific part of the guidance. So that was an intentional move on staff's part.
Director Murphy, do you want to further speak to that? Or do you guys want time to talk amongst yourselves too? I mean,
I would like to address it further in closing, I think. Let us make sure we get our ducks in a row. The only other piece that I would add is, I think that we would be looking into working on guidance on this and other issues associated with the 900 series. So if that tidbit is enough to kind of say that we'll talk about this more in closing.
very good.
That's what.
Other questions from commissioners? Ms. Gutierrez, would you like to?
I might just add, I think just one clarification is that if there is remediation at the site, the entire potential impacted area of soil would be characterized. I think what the clarification we're looking for is whether the exceedance at the going below the 3 feet, it has historically not been considered a violation of the 915 table. So we're not asking that that area of potential impact not be characterized, but because successful reclamation occurs and has historically occurred within that 3 feet measurement, that we would continue going forward. And that, again, we would be happy to be a part of the conversations with respect to future guidance.
Very good. Thank you for that. I'm not seeing any further questions, so we thank you for hanging with us this afternoon and for continued presentation on our mission change rulemaking. Thank you very much. With that, I believe we would bring in La Plata, San Miguel, and Pitkin counties. And they have 15 minutes if they're still with us.
Good afternoon, commissioners. Are Cheryl Rogers and Lynn Paget with us?
They are.
Great.
I can see and hear all three of you.
Excellent, thank you. My name is Mikey Iatridis. I represent La Plata and San Miguel counties. We have two witnesses today, Cheryl Rogers from La Plata County and Lynn Paget from San Miguel County. Ms. Rogers will begin.
Good afternoon, Commissioner Cheryl Rogers, La Plata County Attorney. We want to address two topics with you today. The first is that the rules should provide a more robust cumulative impact analysis, and the other is that the rules should prioritize the use of existing infrastructure. Colorado Revised Statute 346106 requires a cumulative impact analysis as a tool to protect public health, safety, welfare, the environment, and wildlife. Specifically, it states that the Commission shall adopt rules that, in consultation with the Department of Public Health and Environment, evaluate and address the potential cumulative impacts of oil and gas development. Rule 904B attempts to fulfill in part the statutory mandate by giving the Commission the option of requiring an operator to participate in studies evaluating cumulative impacts, but only as a condition of approval of an oil and gas development plan. By limiting the requirement that operators participate as a condition of approval of only new facilities, the proposed rule essentially modifies the language of the statute, so cumulative impacts are evaluated only as to future oil and gas development. As such, if the rules remain unchanged, the Commission is fulfilling only a portion of its statutory responsibility. Equally important, though, are the consequences of this decision. We have previously shown this map of the various oil and gas facilities in just La Plata County, and have also described how our field is 30 to 40 years old. By limiting participation in studies to future facilities only, the Commission is walking away from an opportunity to allow the past to inform the future, a significant set of data, and the opportunity to understand the baseline against which new impacts may accumulate. In our opinion, it is a significant oversight to not take advantage of this historical information to learn, among other things, how infrastructure ages and how impacts that have existed for decades impact the environment, and how those impacts might be remediated to the greatest extent possible. It appears that many of the studies to be conducted will be performed by CDPHE or third parties. As such, the burden on existing facilities to participate should be minimal and outweighed by the importance of the information gleaned. There has been considerable testimony in these hearings about the need for additional data and information, and the Commission appears to be unnecessarily limiting itself in this regard. Our request to the Commission is to implement the statute as written and evaluate and address cumulative impacts of all oil and gas development. Our second topic relates to the use of existing infrastructure. Again, here's a map of our community, and every one of these oil and gas facilities represented by red triangles and the orange squares use existing road access and a network of various types of pipelines, gathering systems, utility lines, and water lines that are not depicted on this already busy map, but are observable when one travels across our county. We strongly believe all the rules should consistently prioritize the use of existing infrastructure to prevent further impacts and degradation of the environment. One such example where this could be achieved is Rule 901E. Rule 901E deals with gas capture plans and requires the operator to provide a description of the location of the closest or contractual natural gas gathering system. The use of or rather than and allows the operator to choose between the two options, and the decision may be based upon improper factors such as cost. If the word and is used, the Commission ensures that information is provided about the closest gathering system and the capacity of existing infrastructure. We also request that a new section be added to Rule 903E1, which states that if the operator plans to connect to a gathering system other than the nearest system, the operator must explain why and properly evaluate the impacts of this decision. And now I turn it over to Lynn Padgett from San Miguel County.
Thank you. I'm going to try and start sharing my screen if possible. Cheryl, I think you have to unshare.
They have.
Thank you so much. Okay, thank you. So you don't need an introduction. I've been here several times, but I do want to say thank you to the commissioners and to the staff for hosting us again this evening. I have a subset of 7 topics that I covered in my written testimony that I'm going to bring up tonight. The need for the revised definition of remediation, requiring 8 quarters of compliance, and new rules should apply to existing facilities, which Cheryl largely just covered. The first thing is definition of remediation is too narrow. It should reflect that remediation is not merely a process, but instead is the activities that result in measurable goals and objectives that protect public health, safety, the environment, welfare, and wildlife. The revised definition, in our opinion, of remediation is needed. And you can see the existing one from October 20th at the bottom of the screen. So our recommendation is to change the remediation definition to remediation or remediate means a cleanup or removal to prevent or minimize the past, possible current, or future release of harmful substances to prevent an unacceptable threat to the present or future public health, safety, welfare, or the environment and wildlife resources. And there is a precedent for this. We can find it in the Colorado solid waste regulations. they state that remediation or remediate means a cleanup or removal to prevent an unacceptable threat to public health, welfare, or the environment. My second topic is 8 quarters of compliance should be required. 4 quarters or 1 year of sampling and analysis of contaminated groundwater that shows compliance with Table 915.1 and the Water Quality Control Commission's Regulation 41 is just too short to demonstrate the sustained compliance in normal conditions. To better account for variables such as groundwater elevations, recharge rates, flow volumes, contact times, monitoring and evaluation periods need to demonstrate regulatory compliance and remediation success. These are often 3 to 5 years to make sure that they're measuring what's called normal conditions, not just a favorable anomaly. So we recommend replacing 4 with 8 consecutive quarters. And again, precedents exist. For example, the Colorado solid waste regulations require 3 years or 12 consecutive quarters. If I look to the EPA's National Monitoring Program, it requires post-project monitoring for 3 to 5 years. And next, again, to touch on the important topic of the need for new rules to apply to existing facilities. I can't understate how important it is what Cheryl just said, that Senate Bill 181 directed the Commission to address the potential cumulative impacts of oil and gas development, not future, but all. And so we're recommending that 901A be amended so that there's an additional part to allow the director to require an operator to participate in studies evaluating cumulative air emissions, impacts of oil and gas development in consultation with CDPHE. And earlier today, there was testimony about the need for consultation with Colorado Parks and Wildlife. I think that's important to consider as well. And I have a map as well to illustrate the importance of applying the new rules to existing facilities. In San Miguel County, all of our oil and gas wells, and this is just half of our county, it's the western half of our county, where we have the highest concentration of wells in Andes Mesa Field, which intersects Gunnison sage-grouse production areas. Of the 220 wells ever drilled in San Miguel County, 130 or 60% will be reclaimed in the future. Most are within this production area and habitat. And so we really feel that the new rules need to apply to existing facilities and wells in order to be protective. Thank you. And there's a legend that I'll submit with my slides for the map. But that concludes my conversation, and I can take questions.
And thank you, commissioners, for your consideration and your attention. We really appreciate the work that you're doing. And that concludes our oral testimony.
Thank you very much to all 3 of you, and thank you for your continued participation with us. I've always felt that your communities do a very good job of pinpointing specific suggested asks, which is very helpful. Although I do have a question for Ms. Rogers. Your testimony concerning the 904 cumulative impacts, and that we trigger that off of as a condition of approval for an oil and gas development plan. And you expressed a concern that that might leave out sort of evaluating past cumulative impacts or looking at past practices. And I'm very familiar with your field, obviously. But in looking at your previous statement and then at your response, as well as the red lines, I didn't see a specific sort of ask on that other than the statement that you made. Did you have a specific ask is my first question. And then secondly, and I might ask AG Minor to be available, but we get involved with oil and gas as it is, as a new development plan comes to us. And so to a certain extent, that's when we would be able to do the cumulative impacts analysis. And then thirdly, that's kind of all over the place, but thirdly, looking at the language that we have right now, I think that if we were to ask an operator to participate in the study evaluating cumulative impacts, I think we could actually go back in time and look at the impacts that existed in the field as compared to the new impacts from the operator, et cetera. So that was a really poorly formed question, but maybe it's more of a launching point for a discussion.
Yes, and I considered and tried to find a convenient place where the language might fit and decided it would be best left to the experts. I don't know that it fits neatly in the rule that we cited, but we do feel like there's a need to make sure that, you know, the history that we've been through, that everyone learns from that. You know, I think we all understand the importance of looking at history, and that should inform our future practices. And I think as the holder of permits, that all operators should be required to participate, particularly if it's not at their cost and expense, to participate in whatever studies either CDPHE or the commission might think are advisable to better understand what's happening in the field. And I think that's advantageous to everybody. And we've heard a lot of conjecture and what's the basis for things. And I think it would just go such a long ways in the future.
Yeah.
And we're at the tail end of our production.
Right.
And so we're kind of, you know, working our way through the pipeline, and it could be educational to everybody else as to what happens for us.
Mm-hmm. Okay, and you know, maybe it is something that we can, I mean, assuming there's some support for this, maybe that's something we can tuck into the statement and basis and purpose, is that studies, you know, for mature fields would look backward as well as forward, or something along those lines. I guess I'm one commissioner, I'm in favor of the concept. I don't know exactly how to interweave it into the rule, but I think you know, it obviously does make some sense, and I don't want to miss the direction of 181 that says sort of all cumulative impacts. So, AG Minor, did you want? I called on you, but you don't have to speak at this point. But if you had anything, you could.
Maybe just one small point, Mr. Chair, which is that there is. I think that both your statement and Ms. Rogers' statement is somewhat consistent with what the Commission adopted in Rule 303A5C, which is the Form 2B cumulative impacts requirement that does require reporting on surrounding oil and gas facilities in locations, and as well as 303A5D that requires reporting on sort of surrounding existing non-oil and gas industrial impacts. So I think there is a step towards considering existing facilities through the CIDR database, but of course the submission of those forms, as you noted, would come as currently proposed with the new OGDP application. That is not data that would get sort of reported unless someone is submitting an OGDP. So I think that's my only addition there.
Thank you.
Mr. Chair?
Yes, sir.
If I may, just, I'm certainly no expert compared to you with coming up with a way to weave it in. One thought I had from thinking about other programs that collect data is thinking of some type of periodic report that provides information that could update your databases. I think that's a standard practice in regulatory programs, and that may be something you might want to consider.
Yeah, and I think that the 1020 version does speak to this annual report by the director that is going to take all of this information. I just think if a majority of us think that it's a good idea to make sure we're not looking backwards, we should, you know, find a way to weave that into the rules. So thank you for bringing that to our attention. I don't want to dominate. Do other commissioners have questions for this panel? Commissioner McGowan.
Thank you, Mr. Chair, and welcome back once again. Nice to see everybody. I did talk to staff a little bit about the 4 consecutive quarters of testing, and I agree sometimes we're looking at cleanup that lasts longer if you're worried, for example, that a plume is moving and has been contaminated. My understanding from staff is that the 4 quarters is kind of a floor, and that if they needed to test for longer, they would work that out with the operator and do so. So maybe some clarification from staff, but I think my understanding is that we would require as much testing as necessary to ensure that we have appropriate cleanup.
Director Murphy or AAG Minor?
So I was fumbling for the unmute, and happy to have AAG Minor follow up. I think that there's flexibility to get more, but the other piece that's important is that we often have several years of monitoring by the time they get to the final 4 quarters. And so we have a better picture than may be suggested by that rule language. And AG Minor, if you want to build on that, or if we want to pull in any of the environmental team, happy to do so.
AG Minor?
Thank you, Mr. Chair and Director Murphy. I can try, and if we have further questions, we can bring in Mr. Axelson. But Director Murphy is correct. So what the rule requires is that there's 4 consecutive quarters of groundwater monitoring that demonstrate compliance with the Table 915 standards for groundwater. So there could be years of data before then, before the site gets into compliance. So it's essentially, there has to be 4 clean quarters before the remediation project is ended. That will obviously vary on a case-by-case basis how long there is sort of in the remediation phase before we get to those 4 clean quarters. Staff's intent there is to recognize that there are things like seasonal fluctuations in groundwater and account for that by ensuring that just 1 clean quarter of data isn't enough to end the remediation project.
Very good. Other commissioners with questions, or Mr. Iotrides, did you want to weigh in?
Yes, please. Thank you. And we appreciate those comments that there's going to be monitoring data before the confirmation sampling takes place. The precedents that Ms. Paget cited are the compliance period, to confirm that it's clean, that at a minimum, 2 to 3 years is required. Frankly, I've done cleanups for 30 years, and doing it only for a year to show compliance seems awfully short to me. I think the standard practice is 2 at a minimum. So we appreciate the distinction, but we were citing precedent about how long it takes to really show that it's clean.
Thank you for that. Do any commissioners have additional questions for this panel? All right, seeing none, thank you again for your presentation and for your thoughtful work product that you've provided to us. It helps us in steering this ship, and we look forward to seeing you again at Wildlife here in a few weeks. With that, I believe we are coming up to probably our last panel. Oh, this is ironic. It's Mr. Jewell, TEP Rocky Mountain LLC. I think he has been the last panelist on multiple days. Latest and greatest, Mr. Jewell. You're on mute, and we want to hear you.
Thank you, Mr. Chair. And I know if you all listen carefully, you can hear the song Closing Time by Semisonic in the background. Here we are. I'll make good use of your time, probably less than 5 minutes here. Admittedly, I will rehash a few points, but we have a little bit of nuance that applies to Tara. So let's knock it out. 3 issues. Number 1, the PIT requirements under 903D6 should not be adopted. The addition of Form 42 notice to 903D1E is unnecessary. And lastly, a few clarification points that we've become really good at, and thank you for that in advance. So Tara echoes industry testimony earlier today regarding 903D6, asking the Commission not to adopt Draft Rule 903D6. The source of the emissions is flash gas from produced water, which is mitigated by separation and vapor combustion immediately upstream of the pit in accordance with APCD issued air permits. These pits are crucial for treatment, storage, and the reuse, particularly, of water for hydraulic fracturing in the Piceance Basin. Furthermore, these pits represent, as industry indicated earlier, one of the major contributions that help us minimize the use of a precious resource. Imposing additional air emission restrictions on these pits will hinder our ability mostly to recycle this water. And we do this more, as you heard from Karis, in the Piceance Basin. We secure all of our water rights legally and efficiently, but Terra firmly believes in maximizing our water recycling potential and don't want that to be hampered. You heard earlier about the benefits these pits provide. You also heard lots of public comments about the effects of drought, fugitive odors, and fencing precautions. But these are all not quite the large issues that they are in the greater Wattenberg area. Our wells are located on the rural western slope, away particularly from the concerns of odor and other nuisances. Our pits are also the proportion and configuration that are in step with our traditional drilling methods, not the larger horizontal operations. So you've heard it before, the one-size-fits-all approach doesn't quite fit here. Our target resource is gas, not the more politically inclined oil, although we are unified as an industry. But as cliche as it sounds, gas heats America. It is a clean bridge fuel, and it does all this while being less intrusive to the matters that are important in this mission change rulemaking. Please do not hamper this production by failing to recognize this key difference in the Piceance rural area as opposed to the Wattenberg. Number two, Terra echoes industry regarding the addition of Form 42 language under 903D1E for well liquids unloading. This additional notice creates an unnecessary burden for the operator, creates redundancies for your staff, and the swapping matters that were already talked about by industry. We respectfully request that the commission remove this additional Form 42 language. And lastly, clarity for operators in Colorado hangs really well on the options that you issue, and we have a really good history of working together on that. But we reiterate this request for clarity, particularly with the definition of flowback. The definition of flowback does not address the difference in the use of temporary equipment used for separation and the use of permanent equipment used for separation. This is an important distinction in practice, and the definition should exclude this temporary use from the full definition of flowback. So that's it. Thank you again for your time. Thank you for staying late this evening and getting this done. So, just to recap, the pit requirements on 903D6 should not be adopted. The addition of the Form 42 notice is unnecessary. And let's unify again one more time on clarity of definitions with flowback. Thank you very much. Have a great evening.
Once again, a great closer. Do folks have questions for Mr. Jewell? All right, Mr. Joel, we see no questions. We will let you go. It's 5:19. Do you want to take on, do we have Weld citizens in the house?
Yes, Mr. Chair, we do.
Well, let's bring them on.
Hi, good evening, commissioners. Thanks for bearing with us. Hearing Officer Thomas, do you see Sydney Staub? She will actually be giving the presentation for us.
Yes, we're adding her as we speak.
Okay, thank you so much.
Ms. Staub, if you want to unmute yourself.
Thank you. I'm so sorry about that.
Not a problem. The floor is yours.
Thank you. Hello, my name is Sydney Staub, and I am a student attorney with the University of Denver Sturm College of Law Environmental Law Clinic. I am presenting today on behalf of Weld Air and Water, Wall of Women, and Margie and Lowell Lewis, collectively the Weld Citizens. The Weld Citizens and other members of their organizations have been impacted by some of the most controversial residential oil and gas developments in Colorado, including the first permitted LUMA project, Triple Creek, and the project at Bella Romero Academy. Today, I will be presenting on two main sections within the 900 series, venting and flaring, and spills and contamination. Our presentation will touch on these topics. Regarding the section on venting and flaring, the Weld Citizens suggest the following. Amend 903A1 to strengthen public notice requirements, remove the waiver provision in 903A3, and preserve the language in 903C. For the sections concerning spills and contamination, the Weld citizens suggest that the Commission amend the language of 905A5 for specificity, remove contingency language in 912A5, and amend 912F to strengthen responsibility of the current operator. I'll begin with venting and flaring. The Weld citizens are glad that Rule 903A1 sets a time by which notice of any planned venting or flaring of natural gas must be provided to local government designees and any local emergency response authorities. However, we urge the Commission to also require notice to any owners or residents of building units located within a half-mile of the planned flaring and venting event. Some of the members of the Weld citizens have stated that had they been notified prior to a venting or flaring event, they would have left the area for health concerns. Similarly, to ensure that community members are informed and protected, Weld citizens recommend removing the waiver provision that allows local governments and local emergency responders to waive the notice requirement if they so choose in Rule 903A3. If an accident were to occur during one of these events and notice had been waived, the community members could be put in direct harm with longer response times from local governments and local emergency response authorities. The Weld citizens ask that the Commission preserve the language of 903C, limiting flaring during completion operations to 3 specific circumstances, and decline to adopt changes recommended by some industry representatives in their pre-hearing statements that would remove these limitations. Studies have shown that flaring causes numerous adverse impacts to humans and the environment, generally through excessive methane release, among other greenhouse gases. I will now turn to our recommendations surrounding spills and contamination. In a survey of old oil and gas production records, the EPA has estimated that there are approximately 1.2 million abandoned oil and gas wells in the United States, of which about 200,000 may not be properly plugged, often causing contamination. The COGCC itself has stated Colorado already has at least 215 orphan wells and 454 associated sites, and that they expect there to be more in the coming months and years due to the current and impending bankruptcy of many oil and gas operators. Other oil and gas companies come in and buy some of these wells after the previous operators have declared bankruptcy. These bankrupt operators often claim to not have the funds to clean up the issue, leaving the current operator or the state responsible. Therefore, the Weld citizens ask that the Commission amend Rule 905A5 to specifically designate responsibility to investigate and remediate any soil or groundwater contamination at a current or former oil and gas location or facility to the current and or previous operator in order to ensure remediation. The Weld citizens request that the term "upon request" be removed from Rule 912A5 in order to ensure transparency and accountability among operators when cleaning up spills or releases that do not meet the reporting requirements of Rule 912B. In order to maintain consistency with our recommendations regarding Rule 905A5, we ask that the Commission amend Rule 912F to state if the responsible operator is unable to mitigate the open spills and releases, it will become the responsibility of the buying operator to do so. Thank you so much for your time, and I'll be happy to answer any questions you may have.
Thank you for your presentation and for your continued work on behalf of your client group. We appreciate it. Do commissioners have questions? We would like those slides to be delivered to Ms. Larson, if you could do that, or Mr. Thomas. All right, I'm not seeing any specific questions. So again, we thank you for your continued work with us and the work you're doing. So thank you very much.
Thank you.
Mr. Thomas, am I correct that the United Water and South BB folks, they need to go tomorrow because of a witness problem?
You are correct. I spoke with Mr. Lewis Prescott on their behalf, and they've agreed to push to tomorrow as well.
Okay. All right then. Well, we are mostly caught back up. We're 5 minutes behind, or 5 minutes plus questions, so that's good. And I think today was a very constructive and robust presentation from folks as well as good questions from commissioners. So I think we did a good day's work, guys. We now will break for the evening, and I'll give commissioners a chance to see if they've got any last words for the evening. But and our schedule contemplates that we would reconvene on Wednesday, October 28th at 9 a.m. With that, does any commissioner have anything else good for the calls? Otherwise, I think we're looking for a motion to adjourn until tomorrow morning at 9.
So moved.
Second.
We have a motion and a second. Any discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? We are adjourned. Thank you, Colorado. See you tomorrow morning.